Good morning.
Good morning, Your Honor.
Morning, Your Honor.
Morning.
Good morning. Good morning.
Are we all set to go?
Yes. Yes.
Right. Mr. Bumahab is your witness, I think. Sorry,
Yes,
yes, it's your witness, yeah.
Yes, thank you, Your Honor. Mr. DeWolf will introduce the witness.
Yeah, should we start with the swearing in, Ms. Quaddy?
A little loud.
Thank you. Please, can I confirm whether you'd prefer to swear on oath or by affirming?
Sorry, I didn't get that.
Please, can I confirm whether you would
Yes,
prefer
swear with this, yes.
on oath? Thank you.
Yes.
Can you please confirm your name and occupation for the court's record?
John Cameron, Director.
Please repeat after me. I swear by the Almighty God
I swear by the Almighty God
that I will say nothing but the truth.
that I will say nothing but the truth.
Thank you, Your Honor.
Thank you, Mr. DeWolf. Right.
Thank you, Your Honor. Good morning, Mr. Cameron.
Good morning.
I'll just take you to your three statements very briefly. The first one is at C11, page 229. You'll see that pop up on screen very shortly. Can you see that on the screen?
Yes.
Is that your first witness statement? You recognize that statement?
Yes.
And if we can go to page 248 of the bundle.
Yes.
Just wait for that to load. Do you recognize your signature there? Is that your signature?
Yes, it is.
And do you wish to make any corrections to this statement?
No.
Okay, thank you. And you gave a second witness statement as well. That's at C13, page 265.
Yes.
Do you recognize this statement?
Yes.
And then if we move to page 273. Is that your signature there?
Yes, it is.
And do you wish to make any corrections to this statement?
No.
And then you gave a third witness statement. That's at C15, page 281.
Mm-hmm.
Do you recognize this statement?
Yes.
And then 291 should be the signature page for that statement.
Correct.
Do you
yes.
recognize that signature? Is that your signature?
Yes, it is.
Thank you, Mr. Cameron. No further questions.
Thank you. Mr. Bohr.
Thank you. Good morning, Mr. Cameron.
Morning.
I'm going to start by discussing your role and involvement in GSS, if I may. In your second witness statement, you say that you began with about 10.5% of the beneficial interest in GSS. That's correct?
I believe it was 10.33%.
Okay. And you still have that beneficial interest, as far as you're concerned?
No.
How did you lose the interest?
Well, essentially, I've been marginalized from the company and left the company around 2000 and I believe it was around 2018, if I'm correct, my recollection.
You say you've been sidelined, but if you're a shareholder, then you'd still hold a beneficial interest in the company, wouldn't you?
Well, you would think that I would have a right, but obviously my rights were removed when the failed agreement never came to fruition. And what ended up happening was that Mr. Araj maintained control of the company's beneficial owner, and I never had any of the shares that were initially to be transferred to me from EVL or ECL, so EVL in this case. So I ended up having no authority or control over any interest in the company.
But the shares were always held beneficially, weren't they? In other words, the nominee.
Sorry?
There was always a nominee shareholder, wasn't there?
There was, while we were working together with HSBC, yes. Until,
No, as well as
until
being-
Go ahead.
No, I'm sorry, go on. You're saying.
I was saying that prior to having HSBC's debt settled, there were nine beneficial shareholders, as you know. I was one of them.
Now, as well as being an investor, you were heavily involved in managing the business, weren't you?
No, I had no experience in the PC strand industry or sector or product. And one of the UBOs, Lorenzo Faccanelli, who was also a provider of the machinery, also was an investor and shareholder in a company in North America that produced PC strands. So he was the one who sourced our general manager for us. Our first general manager, his name was Vittorio Kopp, and he managed the company.
Well, you said yourself in your second statement that you were involved with the recruitment of the general manager. So that's correct, isn't it?
I'm sorry, could you repeat that?
Yes. You say yourself in your statement that you were involved in the recruitment of the general manager. So that's correct, isn't it?
The recruitment of the general manager for GSS?
Yes. But we can go to C13, page 267. Let's just have a look. If I may pull that up, I think we can do that.
C13. I'm on 267. Which paragraph?
Give me one moment. No, paragraph 15.
No, what I state here is that he.
The first GM of GSS was Vittorio Cha, who was referred to me by one of the equipment suppliers. So the suggestion that referred to you.
That's right. That's very different. That's very different than recruited.
When they referred to you,
I just explained to you that the equipment supplier is in fact one of the UBOs, Lorenzo Faccanelli, that I mentioned to you, who was a shareholder in a similar company called Strand Tech Martin in the United States that produced PC strand, in fact, using the same machinery supplied from Eurodry in Europe. And he was the one who essentially stole away Mr. Kopp from Strand Tech and brought him to us.
Right. But you say at 16 that the GM of GSS reported into me in relation to any commercial sales or marketing aspects of the company. In other words, yes.
Once the company eventually started operating very haphazardly, I might say, because we didn't have power connected for several years, I was basically the shareholder or collective UBO representative on commercial matters, whereas Mr. Araj was the representative on financial matters, representing the UBOs.
Right. So, and your role was to assist the senior management on the operational side.
My role was to, help facilitate whatever they required to get their job done.
And you say that you had a similar role in Odyssey.
So in Odyssey Fasteners, we had prior to Odyssey Fasteners being formed, we were manufacturing. I was in the business of manufacturing wire, both bright, which means plain wire from wire rod, and galvanized wire. There was a company located in Jebba Ali called Dubai Wire that was a large manufacturer of fasteners. In fact, they were the largest manufacturer in the Middle East. And the general manager of that company, who I met from time to time through trade shows and whatnot, approached me, and he was disheartened with his relationship with Dubai Wire, and he was wondering if there was an opportunity to move on. He happened to have a relationship with Hitachi Koki for exclusivity to supply fasteners to Hitachi in the United States. And essentially, he proposed to us that if we could build a nail facility similar to what he had in Jeb Alley, he could have that contract migrate over to our new company. So then after a series of meetings with him and then with the folks from Hitachi, it became apparent that that would indeed happen because they were not happy with their current supplier, Dubai Wire. And he ended up joining us, coming on as a general manager. That's how he came to be.
Moving on to your role in signing documents, you accept, don't you, that you sign numerous documents on behalf of GSS?
Well, we had 9 UBOs, and we certainly couldn't bring 9 people to the office or wherever they had to go to sign a document at any given time. So it was logical to nominate 1 or 2 persons to sign on behalf. And they were initially myself and Ezelddine and Araj. Later on, I believe 2 others were added. Wasim, I forget his last name, who works with Evolvent Capital. And I believe the financial controller at Evolvent Capital, I can't remember his name.
And you also signed as a director or shareholder resolutions. That's correct as well, isn't it?
We really didn't have, actually, we didn't have a formal board. If you're referring to a resolution that was required by the bank, we would have been provided with a format from the bank and signed. So,
well, let me take you to D24 501. I'll pull that up on the screen.
One moment, please.
You can see it on the screen in front of you. If we just scroll, this is the resolution of the board of directors of GSS.
Yeah, so if you look at that document, those are the 2 individuals I was just referring to that were added as signatories. If you go up, scroll up, you'll see Mr. Varghese and Mr. Galliani, who were both employees of the Evolvent group at the time.
Right, but this particular resolution is signed by you.
By myself and Ezelddine, I just mentioned to you that Ezelddine and myself, or Mr. Araj and myself, were nominated by UBOs to sign on behalf of the company because it wasn't practical to have 9 people, 9 UBOs, sign off on all these documents.
Well, but you had particular expertise, didn't you? I mean, you've discussed some of that just now, and you in fact mentioned in your witness statement, I believe, that you had operational expertise. So you were being
There's a vast difference between...
Mr. Cameron, just, I'm not criticizing you at all, but because you're online particularly, if you can just wait just one more minute longer, so you can hear a question, and I'll give you room to answer as long as you wish.
Okay.
The point I was putting to you is that you had operational expertise, and therefore you were being chosen because of that particular ability of yours. Okay, so I was just going to say to you, I had operational expertise in producing wire. I had no experience whatsoever in producing fasteners or PC strand. All steel products are not one and the same. They're very, very different. Particularly PC strand is a very unique product. I had no experience. An opportunity came our way for a PC strand project, and which is, by the way, was initially going to be established in Qatar, and it ended up falling through. And the same supplier we had used previously, the gentleman I mentioned, Mr. Fakanali, was supporting that project. And once it fell through in Qatar, he approached us here in Dubai because there was a short supply in the Middle East. And he had done all the studies and whatnot on the viability and the commercial viability of the project. And it made sense for us. And that's how we got into the project. I had no experience in PC strand. If you're not from the steel industry, you may not be able to differentiate, but there's a vast difference between PC strand, wire, coil, pipes. Being
an expert or having expertise in one particular area does not mean that you do it. You can apply that to all products and processes.
Moving to your relationship with Mr. El Araj, you both had an interest in a company called Technocram. That's correct, isn't it?
Yeah, Technosram. Now,
Yes.
can I answer that?
Well, it's a yes or no answer. So you had an interest with Mr. El Araj in that company?
No, I did not. The company was owned by Mr. Araj. That I should, if you're not aware, Technosram changed their name to Specified Wire Products. And Specified Wire Products was owned by a company called GSS Holdings. That in turn was owned by a company called GSS Investments, which was owned 100% by Ezelldine Al Araj. All those constitutional documents are within the data pack.
What was your involvement with Technocram then?
There was no involvement. It was a plot adjacent to the main facility plot where the factory was located, and it had a very small shed in it with 4 offices. And the reason why we needed that space is because the plot where the factory was constructed didn't have enough outside storage for the raw materials or the finished product. So we needed to have more space. We tried to acquire the plot behind us. We failed. And then this plot became available. And so this plot made sense, and that's why it was acquired. And ultimately, it was owned by the same company that owned GSS. So you had GSS Investments owned GSS, GSS Investments owned GSS Holdings, which in turn owned Technosram, which name had changed to Specified Wire Products. And the ultimate beneficiary of both of them was Ezelldine Al Araj.
Do you have other business cooperation with Mr. Al Araj, other businesses that you're involved in?
Do I have other businesses?
With which you're involved in with Mr. El Araj?
I have no businesses with Mr. Araj at this moment. I had historically, I had some businesses with him, yes.
What businesses did you have with Mr. El Araj?
We were involved in a few. One was, there was a period of time in the UAE where, if you're from the UAE, you probably know, around 2006, 7, 8, 9, 10, 12, there was a lack of energy, and particularly in Sharjah. And so everyone was relying on generators to operate, including even residential buildings. So we got involved with the manufacturer of generators from China, and we were leasing out and selling generators, for example. That was one. We had a small travel company for a period of time. Of course, you're already aware of Odyssey and Precision. Really nothing else of substance I can think of.
And when did you cease having business with Mr. El Araj?
I have not communicated with him probably for 6 years. Last time I had any business with him would have been probably around 2018, when I completely exited all dealings with him. That was when I essentially walked away from GSS.
And when you walked away from business dealings with him, was there an agreement between you in relation to the business interests that you had together?
No.
I want to turn now then to the HSBC loan. So the parties have agreed that HSBC lent around $99 million to GSS and Odyssey. You'll recall that, correct?
Yes.
And the UBOs that you mentioned, they signed all money guaranteed in favor of HSBC, correct?
Yes.
Then in 2014, there was a restructuring of the HSBC loans, and that's because there was a realization that GSS and Odyssey wouldn't be able to pay back these loans, correct?
Yes. Can I comment on that?
I don't want to shut you off, but I
It's
mean, I'm
okay,
going to be looking for a yes or no answer there. I mean, the point I'm just going to ask you the next question, but you can expand upon what you wanted to tell me a moment
Sure.
ago. The next question is that I was going to ask you whether you were worried that HSBC would call in your guarantee.
Well, throughout those few years leading up to the restructuring, we had several sessions with HSBC. Generally, it was myself, Mr. Araj, and our CFO at the time, Shrikant Chakravarti. Many meetings with HSBC. In fact, you could see that the debts for Odyssey and GSS were rolled over a few times before we reached the point where we restructured. During those many discussions, it was made clear to us from HSBC that they did not want to take any action due to some of the UBOs being high-profile individuals, namely Mr. Ahmadi and Sheikh Thani. Further to that, we were all well aware of who Mr. Ahmadi was and what his position was, being the Minister of Finance in Qatar. I believe he was the chairman of QNB, in fact, and I think he was also a director of QI, the investment authority. So we had him as our, backstop, so to speak, and we knew that as long as he was there, it was very unlikely that HSBC would move against us. And HSBC themselves spoke of this multiple times during our sessions with them. And so they were also in a corner looking for a solution. So to answer your question, no, I was not really worried. Further to that, there was significant security in place. If you look at the assets of the two combined entities at the time, I believe it's around $15 million. I could be wrong, plus or minus. There was also an assignment of Hitachi Koki proceeds. The year in question, it was only $34 million because the company had just been dumped and was in the process of being relocated to Oman. The year prior, I think it was $58 million. And then as it moved forward, it went up over $100 million. So the combination of the security in place, the PGs from the 9 persons, and the fact that 2 of those 9 persons were the gentlemen I just spoke of, gave me a fairly large degree of comfort.
But you accept, don't you, that HSBC could have come after you under the guarantee? There was that possibility. You saying that's just impossible? They wouldn't do that.
No, I didn't say it's impossible. I said that they themselves told me that they did not want to do that. Furthermore, if they did do that, I explained the securities that were in place. My net exposure would be relatively minimal. If they in fact did.
You say that, but of course there'll be practical differences, difficulties in realizing that security. Correct, or there could well be. One can't guarantee that security can be easily realized. For example, assets like machinery depreciate over time. They may be hard to sell. You may not find a buyer.
I believe the value that I just quoted was the insured value of the machinery in the year in question. So in other words, that was the current value.
I mean, clearly a deal was done and a large amount of money was paid to HSBC. So you must have felt that there was some need to pay HSBC $25 million. You certainly wouldn't have stood by and allowed that to happen if you felt there was no need.
Well, I mean, you understand what was contemplated amongst the parties. And so there was an opportunity due to the circumstances I just explained to you, where we had an opportunity to purchase where the HSBC debt could be purchased at a discount due to the collective circumstances of everyone, including HSBC at the time, who wanted to get out of this mess. And so there was an opportunity. I wouldn't say, I would say it was an opportunity for everyone, actually.
Okay, well, and also, I mean, what you just described helpfully is that you were involved in discussions with HSBC. So is it right to say that you were involved more generally in the restructuring of these loans? No,
I was involved, when I say I was involved, this is prior to QNB, prior to approaching HSBC to purchase the debt, prior to us reaching a point where Mr. Mohammad got involved and brought in Madidazi and Araj, Nadar, etc. Prior to that, we were working with HSBC to keep the lights on, so to speak. And so they knew we were working hard to try to find solutions. In fact, we brought in various prospective buyers, 2, 3, 4 of them. I think even KHALED brought 1 or 2, and none of them came to fruition. So HSBC was giving us a bit of a leash to try to get things done. So what they were doing is they were simply rolling over their debt. They weren't restructuring it, they were just rolling it over. So although the term had expired, they were rolling over. That's what I meant during that period of time leading up to the QNB/HSBC transaction.
And as the restructuring discussions continued in the years that followed, you learned about them from information provided to you by Mr. Araj and Mr. Dazi and other people. So people would have updated you on the restructuring plans.
You're referencing the HSBC QNB restructuring, correct?
Yes, that's right. And yes.
Yes, I was updated by, yes, you're correct.
And that's, I'm taking this up to the point of the QNB alone as well. In other words, you were being updated all the way to that point.
I didn't hear you. Could you repeat
Yes,
that?
you're being updated up to the point of the QNB loan, just to be clear. So the period I'm talking about is up to that point.
I really didn't get much feedback on what discussions were taking place with QNB. Actually, probably next to nothing. I was updated on negotiations with HSBC fairly regularly, mostly by emails that were circulated by Mineo, some from Medidazi. To my recollection, Medidazi managed most of the QNB himself directly. I don't think there was much really to update me. We knew what he was trying to accomplish, and he told us it was agreed to, and there wasn't much more to it.
Can we go to C13, page 272, please? It's just looking at your second witness statement to paragraph 47.
Okay.
This is the part of your second witness statement when you talk about the various representations that were made. And this is about the equipment leases. And you say, my understanding was that the HSBC loan would be funded by one or, I think you mean, well, I'll read it first, would be funded by one or both of the equipment leases, pursuant to which each of the SPVs were to receive a yearly lease fee of 16.5 million. Do you mean a QNB loan? Or did you mean to say HSBC loan?
No, the loans. So Aladi, EVL, for example, was to acquire the assets of GSS and then lease them back to GSS. So what I'm referring to is the lease payments were to be made to Aladi, EVL in this case.
Right. So, and you say one or both equipment leases. So,
well, as you know, yeah, there. As you know,
wait. My question, Mr. Cameron. You'll have a chance to answer it.
Okay.
You say one or both equipment leases. So the question I'm asking is that it could just be a GSS equipment lease. That's the larger one.
Both leases were to be for an equal value.
Well, you say one or both. One or both.
Yeah. As far as both leases were to be put into effect, both leases would have contributed towards the debt routed through the two SPVs, and both had. Sorry, go ahead.
Yeah, I just want to be clear because obviously it's very important because this goes to your representation, and so is what you're saying that you want to take the words by one or out of that first line, and you want to say funded by both the equipment leases. Is that really what you want to say?
I think if you look at the QNB transactional documents, it only references the EVL and GSS lease.
They do.
In actuality, the understanding that we had as a collective was that it was going to also be supported by the ECL Odyssey lease.
Right. Okay. Well, you didn't quite answer my question, but I'm going to leave it to your counsel to come back on that. We've heard your evidence. Now, you say that this was conveyed to you by Mr. Darcy. Is this just Mr. Darcy who told you about the equipment lease? The leases?
Well, when the initial structure of the transaction was presented by Mr. Dazi, which is outlined somewhere in one of these documents. And, I mean, there was a personal loan that KHALED was borrowing from QNB, and then those loans were to be supported by the two SPVs would be incorporated. They were going to purchase the assets, lease the assets back. The revenue from the leases was going to flow up to KHALED so he could settle the QNB loan. So that was the initial structure laid out by Andy. So everyone was aware of it.
Right. When did Mr. Darcy tell you this about the equipment leases?
I can't recall for certain. I can't recall for certain, but if you look throughout the document packs here, there's an email where a couple of them, in fact. One, I believe he emails Ali Shree's brother and he lays out the plan, and another one, he actually shows, I think, 8 steps, and he outlines what I just mentioned to you. Well, so if you look at the date in that document, it would probably be in around that time.
We'll come to the emails, but your evidence, as far as we understand it, is that there were conversations between Mr. Darcy and yourself. And that's really what you're relying on in terms of the representations that were made to you. Is that correct? You're not relying on written representations. You're relying on things that Mr. Darcy has said to you.
Yes, it was very clear that was the plan. Yes, presented by Darcy, right. Mr. Darcy. Yes.
And again, the question I'm asking is, when did he say to you that the QNB loan will be funded by equipment leases? When?
I just responded that I can't recall exactly. It would have been obviously the period leading up to the approach to HSBC and QNB for restructuring, when he laid out his plan, and he sought approval from, KHALED, for example, and from KHALED, the two KHALEDs, in fact, KHALED ALMHEIRI and KHALED MUSABEH, and it would be around that date. I don't remember the exact date. I would presume it's 2014. I guess.
How did he tell you? Was it on a phone conversation? Was it at a meeting?
It probably it was discussed on a regular basis. I'm sure it would have been both. So it's not something that was mentioned one time.
Right. So you're saying it was done in phone conversations and in in-person meetings?
Like I said, I can't recall specific dates. It was something that was discussed frequently.
And do you remember any meetings where he said this to you?
Do I remember, sorry?
Any meeting where he said this to you about the equipment leases?
Sir, we had so many meetings, so many calls. I mean, dozens and dozens and dozens and dozens. It was discussed fairly often. I couldn't give an exact date.
Right. And other people were at those meetings, presumably?
Well, generally, the people involved in those discussions would be myself, Mr. Araj, Mr. Najjar, and Mehdi Dazi.
And what about the claimant to these proceedings, Mr. ALMHEIRI?
From the get-go, Mr. ALMHEIRI made it clear that Mehdi Dazi was basically representing him to restructure this, and all communication should be routed through Mehdi, which ended up happening.
The points you just made about these numerous meetings and phone calls and conversations and the people that have attended, they don't appear anywhere in your witness statements, do they?
I don't know. If not,
Mr. Dazzy, you mentioned, was acting for Mr. ALMHEIRI, but actually he was acting for all the UBOs, wasn't he?
No, he was representing Mr. ALMHEIRI. It was made crystal clear to us all at the beginning.
Well, Mr.
In fact,
Dazzy
he was
involved,
nominated by him.
right? Well, he was involved. Mr. Dazzy was involved in the restructuring discussions with HSBC, as was Mr. Nejar, and they were being carried out on behalf of GSS and Odyssey.
I don't think
Well-
Mr. Dazzy was involved in those discussions with HSBC. I believe that was just Mr. Nejar. I could be wrong, but I think it was Mr. Nejar only with HSBC.
And you also say in your statement that Mr. ALMHEIRI paid Mr. Dazzy.
She does a reference to an email or a WhatsApp from
Yeah, I
Mr.
can show you
Nejar.
that. Right. So that's D101, page 1210. I think this is what you're referencing.
Yeah, so that's looks like a WhatsApp message from Mr. Nejar.
Right. So, and what you suggest in your witness evidence is that Mr. Dazzy was being paid by Mr. ALMHEIRI, correct?
Well, I think what I'm doing is I'm just recounting what Mr. Nejar has raised to me in this WhatsApp.
Right. So, I mean, the point I'm going to ask you is that given that, and given Mr. Dazzy's broader role, you couldn't have thought that everything Mr. Dazzy said came from the claimant, could you?
Well, I had no reason whatsoever to doubt that it did. In fact, there were several points along the road where myself specifically, wanted to see certain things done and agreed to. And I went to Maddie, who in turn went to KHALED, and he would come back and tell me if it was accepted or rejected or what have you. He was always representing KHALED.
Right. Well, when Mr. Dazzy talked about the equipment leases in these many meetings you referred to, at no point did he say that he was speaking on behalf of the claimant in those discussions.
As I said, Maddie Dazzy was tasked by the claimant KHALED to solve the problem, come up with a structure to solve the problem. And this was the structure that Maddie Dazzy came up with. You have to understand that Maddie Dazzy, Neil Nejar, and KHALED for that matter, all come from financial community. They all have investment banking, finance experience. This is what they do for a living and have done for many years. They were the ones tasked with putting this together. That's their field. That's their expertise. I'm from the steel industry.
No one said, when I say no one, I mean particularly Mr. Dazzy, when the equipment leases were going to be signed, did they?
I believe that in the transactional documents with QNB, there was a timeline specified when they had to be signed. I could be wrong, but I believe they were post-closing conditions, or whatever you refer to it as, and that certain documents had to be signed. I think maybe some pre, some post, I don't know. But there was, to my recollection, there was a timeline where these documents had to be signed.
Right. Well, I want to focus on your allegations as they're actually put. And again, I mentioned this before, that what you have said, what your lawyers have said on behalf of you, is that Mr. Dazzy made representations to you. And the point that I'm making, forget the documents for the moment, is that when he made these representations on your case, he did not say when the equipment leases were going to be signed, did he?
You mean specific day that they're going to be signed?
Correct.
No, he didn't.
And so presumably you understood that it would be or could be later than the time that you signed the indemnity agreement.
Possibly, but at the end of the day, that really was secondary to me, because I signed the indemnity agreement amongst other things. Well, first and foremost, because I was told that concurrently, both Ezelddine Araj and Mr. Abadi were signing indemnity agreements. So
Well, we'll get
even
to
if
that.
it took time to perfect that, I felt I was covered.
Right. So, but you understand that the signing of the equipment leases involved EVL and GSS, for example, on the GSS side. So there may well be delays before those equipment leases are put in place. You would accept that?
Well, as I just said to you, at the time I provided the indemnity, I read the document, and the document said that there were deliverables pre and post. The deliverable that you're referring to, I believe, is post. So that's what I knew.
When you say document, just to be clear, you mean the QNB facility?
It referenced transactional documents. I don't have in front of me, I'm crystal clear enough, but I do know, and even from reading all the correspondence back and forth between the lawyers in this case, I do know that there was a requirement for certain documents, ones that you just referenced, to be signed post-closing the QNB transaction or post-disbursement or what have you. And because I see the arguments between you lawyers referring to the dates and the delays and all these things. So I was aware that certain documents had to be executed post-closing.
So you mentioned that the QNB loan facility documents, or sorry, you said transaction documents. I apologize. So isn't the reality that you're actually looking at those documents and relying on those yourself, as opposed to anything that Mr. Dazzy or anyone else was telling you?
Actually, like I
Isn't
said,
that really what's going on here?
No, as I said, we all had a role to play. You have to remember that we were all, until the relationship broke down, we had worked together for many years. The various parties involved, there was a high level of trust. I was told that Mr. Amadi was going to be a guarantor. I just mentioned that, but further to that, I more or less relied on, KHALED. Ezelddine also, by the way, is from a financial background. Mehdi Dazi, Manil, they looked after, for the most part, the banking documents. That's basically where they they excel. And I did give my comments from time to time, not a lot of them. I had to rely on their expertise. As I said, we were partners. And if you look back at the relationship, examples where we didn't have to put everything in writing are the ownership of GSS and the ownership of Odyssey. We had multiple UBOs, but it was never put in writing. It was based on trust, and that's how the relationship operated. So one person would have its strength in one area, the other, in his realm, and that's how we work together.
You would accept that GSS didn't pay a single cent under the lease, wouldn't you?
I think that's correct, yes.
And you'd accept also that wasn't down to Mr. ALMHEIRI. That wasn't his fault.
I agree with you, yes.
It was partly up to you. It was someone who was involved, one of the UBOs involved in GSS, to progress all this, wasn't it?
Well, it was definitely in my interest to make sure that the companies succeeded in both operating and generating income and servicing the lease agreements. Unfortunately, in the case of GSS, the beneficial owner refused to cooperate. That was Mr. Araj.
You said he refused to cooperate. So you just said?
Yes.
So were you pushing him to sign the equipment lease and he wasn't cooperating?
I was pushing to on both for Odyssey and for GSS to not perfect the leases, but the entire contemplated agreement. I wanted my shares in Eladi to be transferred to me. They were not. And the main reason why Mr. Araj refused to move forward is because the shares that were promised to us were not transferred to us. In order for us to move forward, with GSS, part of the plan was that the debt that was now owned by EVL, which was purchased from HSBC, was going to be converted into equity, so that the balance sheet of GSS was improved to such a degree that we could go and obtain working capital, because GSS no longer had working capital limits, and the steel industry and production of products is very capital intensive. So if you do not have working capital, you cannot procure your raw materials, and you can't operate. So without that cooperation, we were dead in the water. And that's the reason why, in my opinion, why he didn't cooperate.
Why is there no emails from you to Mr. Araj saying, where are my shares, please?
Well, the shares were to come from Eladi, not from Mr. Araj.
But Mr. Araj was the shareholder, the nominated shareholder.
No, the shareholder of Eladi was Mr. Abdulaziz Dazi.
Of GSS.
Mr. Abdulaziz Dazi owned 100% of EVL, correct?
EVL. Okay, I understand. Okay. Nevertheless, there's no email from you to Mr. Dazi or anyone else, in fact, saying, where are my shares, please?
No, there's no email to that effect. You're correct.
I'll come back to that momentarily, but for now, I want to talk about your entry into the indemnity agreement. What the claimant says is that you were involved in negotiating the indemnity agreement and commenting on drafts. Do you recall that?
I recall, I think contained in this bundle here, one or two of my emails to Mr. Dazi with my comments on various points. Yeah.
There's one at D44607. If we go to that, you can see it. Actually, if you go to 608, you'll see your email.
Okay.
So you may want to pull that up on the screen. Thank you. There's an email from you from Friday, May the 22nd. Where you say, hi guys, I don't know who you're writing to there, but I'm assuming, you may tell me I'm wrong, that it's Mr. Dazi. Probably, maybe you're copying someone else when you say guys. Yes, maybe Mr. Araj as well, and Mr. Najjar.
Yeah, if you scroll up, you'll see that
Yes.
Mr. Najjar,
Yeah, I can see that. Thank you. And what you're asking, you said, I've finished reviewing the revised and much improved draft of the indemnity agreement. So it's right to say that you are quite careful in terms of signing documents. In other words, you'd like to know what's in there, and you will make changes or propose changes when they don't satisfy you. Is that a fair assessment?
well, anyone would be, but typically what would happen is whenever we had a document like this to execute, Ezelddine would ask me to review for all of us for that matter, because he didn't get involved in that. So I went through it and I gave back comments. And then if I recall correctly, Maddie went with my comments to KHALED and shared each comment with KHALED, and then respond to me telling me what KHALED would agree to and what he would not agree to.
Okay. If we look at the first line, so you refer to the secured term facility agreement, and you say, can we remove the document reference number from the definition? If we're able to do this and decide not to attach a copy of CFI, we have a possible argument defense against any default event. And so my question is that you're explaining to Mr. Dazi that you want some wording changed because you may well want to rely on it to raise a defense, correct?
It's what it states, yes.
Yeah. And in a sense, what you would like to do is have Mr. Dazi fight your side for you. You want him to go to the claimant and argue your case for you.
If you, as I said, if you scroll up, you will see that Maddie went to the claimant and the claimant responded at all points. So, including one you just read out, and came back to me with his instructions.
Okay, well, we'll get to that. Just as a prior question, again, just to repeat myself, what you want Mr. Dazi to do is go and fight your corner for you. he's your man on the inside.
No, what I want Mr. Dazzy to do is to raise all these points that I've outlined here to KHALED and then come back to me with yes or no. Can it be done? Can it not be done?
Okay, and then as you said, if you go to 607, you can see the email from Mr. Dazzy coming back on the points you've raised. And what he says, so that very first point is an example, not possible from my conversation with Cam, he would reject. So my question to you is, you understand from that when something is wanted from Mr. ALMHEIRI, Mr. Dazzy would go and ask him and then report back on a particular conversation that he had with Mr. ALMHEIRI, correct? That's the way it works.
Well, as I've said twice now, in this particular instance, I provided my list of queries concerning the indemnity agreement for him to go and discuss with Mr. ALMHEIRI and respond accordingly, which he did.
Now, I asked you earlier about when the representation in relation to the equipment leases, or the alleged representation in our case, was made, and you couldn't quite remember a date, and you said it was made on numerous occasions. Let me ask you this, you have this email which may trigger your memory. It's dated the 25th of May. Were the misrepresentation in relation to the misrepresentation in relation to the lease, and indeed the other two alleged misrepresentations, were they made before or after this email?
I think I believe, excuse me, the structure with respect to the leases was raised much before May 25th, 2015. If I recall correctly, it was raised sometime in 14. As I alluded to earlier, there is an email somewhere, one or two of them in the package here. And one of them in particular, Maddie lays out the structure of the whole transaction, 1, 2, 3, 4, all the various steps. Probably at around that time was when the component of having the SPVs acquire the assets, lease them back, and have the lease proceeds go towards paying the debt, probably is around that time that he would have initially raised it to us.
Right, so just summarize your thing with the lease equipment representation that was made before this date, before this email. What about your alleged representation in relation to control, which we'll look at in more detail soon? In relation to that, were you promised control of EVL, ECL prior to this date or after this date?
We were, when I say we, myself and Ezelldine, we were told that we would initially, because we were the only two that were going to stay and operate the company, Mr. Ahmadi had arranged for the debt and KHALED was borrowing the money. So the understanding was initially we would each have 25% of the allowance, or 25% each. Subsequent to...
I'll come back to that, Mr. Cameron. I don't mean to cut you off, and I apologise for doing that, but you will get a chance. I just want to focus on the timing of those representations. Were you told about the control? You'd have control, or even the 25%. Were you told that or promised that prior to this date or after this date?
I believe it was. I believe it was prior to that date. I'm not certain. I would say it was around the same date that the entire transaction structure was laid out.
What about the final representation that an indemnity agreement would be signed by Mr. Ahmadi? Was that made before this date or after this date?
That was made before. It was always, we were always told that Mr. Ahmadi would sign an indemnity. Okay.
Well, now given that you think or know in relation to that representation that they were made before, why didn't you insist that this goes into the indemnity agreement? You were in communication with Mr. Dazzy. You knew Mr. Dazzy was going back to Mr. ALMHEIRI. You were very careful about listing every detail of the indemnity agreement, which caused concern. If these representations were of any importance to you whatsoever, then why didn't you ask Mr. Dazzy to include them in the indemnity agreement?
To include what? I'm sorry.
To include the representations in relation to the
But we were
control.
told that, I was told that the indemnity was already signed by Mr. Ahmadi. That Mr. Ahmadi
And
signed.
this-
Sorry?
You were told that the indemnity was already signed by Mr. Almadi.
When around the same time that I signed my indemnity agreement and Ezelddine signed his, we were told Mr. Ahmadi signed his as well.
A moment ago, I asked you when the representation was made in relation to Mr. Almadi, and you said before this email. And so the question I was asking you, and I'll ask it one more time, is why, let's just focus on that representation,
Yeah.
why you didn't write to Mr. Dazzy in this email and say, don't forget to include the promise in relation to Mr. Almadi. Why didn't you do that?
I was commenting on what I was provided. I didn't even think that that would be, it didn't cross my mind.
Right. I'm going to suggest to you that it didn't cross your mind because, in fact, no one made any representations to you whatsoever.
Well, you're welcome to suggest whatever you like, but that's not the case.
Isn't the reason why you signed the indemnity agreement because you actually wanted to continue with the business along with Mr. Araj, your associate?
Well, I
Isn't
want to.
that the real reason?
I saw an opportunity, which I tried to explain a little bit earlier. If you allow me a little leeway, I can elaborate a bit. We understood that all the UBOs, with the exception of myself and Ezelddine, wanted to exit the business. We were prepared to continue forward under the circumstances that one, KHALED borrowed the money and that the two leases were put in place to service the debt, and three, that the shares of the two Ezelddines were transferred to us, initially 25%, and upon retirement of the debt, the remaining 50% for a nominal fee. So ultimately, once the debt was retired, Ezelddine and I would each own 50% of the two companies. Prior to that, I only had 10.33%. So for me to move from 10.33% to the initial 25%, I was basically two and a half times what I had in hand. I knew that I was protected because Mr. Ahmadi had signed the guarantee. He was the chairman of QNB. He was a finance minister. Certainly, if we would have defaulted in any way, there would have been an opportunity to restructure. They're not going to come after Mr. Ahmadi. And the combination of those things gave me the comfort of moving forward. In addition to that, we were told that, the plan was that the debt would be converted to equity. In fact, Mr. Manil Najjar was made general manager of GSS for that purpose. He was replaced the former general manager, was registered in JAVSA, which is the free zone in Dubai. And his job was to have that debt convert to equity and go out and source us working capital so we could restart the business. That was the plan.
Right. Well, let's break this all down a little bit. We've spoken already about the equipment lease representation. You've spoken quite a bit just now about the representation or the alleged representation in relation to ownership. Again, I want to focus down because it's very important, Mr. Cameron, that we understand, the court understands precisely what the allegations are. In other words, precisely what you say was said to you and by whom. Now, that's very important. So with that in mind, I just want to take you to your witness statement, your second witness statement at paragraph 40, which is at C13, page 270.
Okay.
So if you look at paragraph 40, this is what you say. So unlike most other personal guarantees, you say you had 10.55%. I think when I asked you earlier, you suggested that number was slightly different, but
Yeah, I
don't
think
worry
that's
about
a
that.
typo.
Okay, fair enough. And then you say the shares were intended to be distributed evenly between those four persons that would remain involved in the business following the purchase of HSBC loans. Namely me. I'm looking at paragraph 40, page 270.
Which paragraph number, please? 40? 40?
Paragraph
Okay.
40 of your second statement.
Yes, that's correct. So equally would be 25% each. That's what I just said.
Right. If we could just scroll down to paragraph 40, please. Thank you. Right. So what you're saying here is, just to be clear, you're saying each person was to get 25%.
Correct.
Now,
Initially, yes.
moment ago, when you were discussing this a moment ago, you mentioned 50%. In fact, in your
No, what I,
pleadings, although
I didn't
wait,
say
wait,
that.
for the question. Wait for the
Okay.
question. In the pleadings that were presented to the court on your behalf, it talks about control. It says that Mr. Dazi and Mr. Araj promised you or represented to you that you would have control. But this isn't control, is it? It's a 25%.
What I was saying previously was that initially it was 25%, and then once the QMB debt was paid back, the remaining shares would be transferred to us. So we would then each have 50%.
Right, but you don't say that here. You don't mention here anything about that point where the debt was paid back. Where do you?
I think if you scroll down, or maybe in my skeleton argument somewhere, it states that the balance would be transferred at a nominal fee once the debt was retired. If it's not in this document, it's in another one.
Right. Okay. It's not in this document. We'll look at the other document and see exactly what that says. But the point you just said now is quite important, because what you're actually saying is once the debt is paid back, you would gain control, or gain 50%. In fact, not control.
We would gain the remaining 50%. In other words, Mr. MUSABEH and Mr. Mahdi, yeah. Understand.
Right. But that wasn't going to happen right away, was it? It was going to happen on your version, on your own version, when the debt was repaid.
The final transfer of the remaining 50%, you are correct.
Right. And that debt was never repaid, was it?
No, it was not.
So you can't possibly have a complaint that you never got the remaining shares.
Well, the starting point would have been to receive the initial 25%. We didn't get that.
Right. Well, when did you think you were going to get the 25%? At what point did you think you were going to get that?
Well, I'll tell you exactly. The reason why the 25% was not provided to us prior to the conclusion of the transactions is because we were told by Mr. Dazi that until they purchased the HSBC debt, they had to maintain his brother, Abdulaziz Dazi, as the shareholder of the two SPVs, because HSBC would have copies of the constitutional documents, and they certainly wouldn't agree to a discount or a haircut if they knew that the acquiring party included similar shareholders to those that were being bailed out, so to speak. So he said once the HSBC debt was purchased, then the shares would be transferred to you.
So again, you didn't, once that happened, you never wrote to anybody and said, where's my 25%, please?
Mahdi Dazi was not, and I'm sure you can see from all the communications you have, I don't know how many communications that Mr. MUSABEH shared with you, but he was not a person that was like to document things by emails. There was hundreds and hundreds of calls with him, discussions, meetings in person with him. It was discussed. In fact, if I may, we even flew to Paris to meet with him to try to, when everything broke down, to meet with him to try to convince him to do it. And he was back and forth with Mr. MUSABEH, and he refused to do it. We needed two things to occur to move forward. We needed those shares transferred, and we need to convert the debt to equity, because if we didn't do that, we couldn't attract working capital, and without working capital, we couldn't operate the company. So the companies were handcuffed at that moment.
Nowhere in your statement is there a description of when Mr. Dazi said he would give you the 25%. I mean, you mentioned just now when you thought that would take place, but there's nothing to that effect in your witness statement, in any of your witness statements, as far as I can recall. Do you recall anything different?
I don't think the specific date is in my witness statement. I think you're right.
Right. You also, in fact, Mr. Cameron appeared to say something different in your third statement, and I think you've actually already alluded to this. If we can go to C15, page 286.
Which 286, okay.
Yeah, I'm looking at paragraphs 31 and 32.
Oh, okay.
Of the third statement. And this is the point you were making momentarily, just a short while ago. You said that you say here that you and Mr. Araj would be given a 25% stake in the business, and then on repayment of the QNB loan, you and Mr. Araj would end up with 50% each.
Yes, that's what I was referring
what you're
to.
making, it's not in your second statement, it's in your third statement. And so the point I'm going to put to you is that it's not really that sometime between your second and third statement, it dawned on you that actually you hadn't addressed the allegation as put in your pleaded case. That's what happened, isn't it? And you had to somehow fix that oversight.
I disagree. I would just say it was a clarification.
Well, we will disagree with that. Now, I want to understand how you came to the understanding based on what Mr. Dazzy said. So just again to be clear, it's Mr. Dazzy who promised you control, correct?
Well, Mr. Dazzy promised to transfer the initial 25%, as I just described to you in the timeline. And we all knew that the balance would come once the debt was retired.
And just again, when was that? I realize you may not be able to recall, but you said...
I think I answered that previously. I don't know the exact date. I think it was around the same time that the contemplated structure was laid out by Mr. Dazzy and eventually fine-tuned and agreed to. Obviously, for me to move forward, I don't know about. I'm sure also for Mr. Araj to move forward, certain agreements were and commitments were made to us. Otherwise, why would we have signed an indemnity agreement? We would be no better off than the rest of the UBOs who walked away with no liability whatsoever. So, you know, the commitment that was made was multi-pronged. It was that, you know, KHALED would take the loan, that the equipment lease would be put in place, that we would receive the shares, and everything that I've explained already during our discussion so far. Otherwise, why would I do it?
Well, normally council don't answer questions, but I'm gonna on this occasion do so. The answer is the one you gave previously. You saw an opportunity. You understood that the UBOs, most of them wanted to walk away. You were directly involved. You had operational ability, and you had some assessment of what could become of this company, and you took the opportunity. That's really what it's about, isn't it? That's what business is about, risk, and that's what you did.
Well, I explained to you that the opportunity, partially the opportunity, was the fact that the structure gave us protection in the sense that one of the guarantors was Mr. Mohammad. And if you scroll back to that section of our transcript, that's what I said.
Earlier on, when I put to you about your care that you take in signing agreements, you said something like, "Who wouldn't?" And that point can be made against you too, can't it? In other words, if these things really were the protection that you desired and so important to you, they would be in an agreement, wouldn't they? Mr. Curran?
Yeah, I hear you now. I think it froze for a minute.
I'll repeat that question. I was going to say, if these things were so important to you, then they would be in an agreement, wouldn't they?
Like I said, the group of people involved had worked together for many years on the basis of trust. I gave you a couple of examples which are pertinent to this case. One is GSS, for example. You had one beneficial owner, which was Mr. Ezelddine Araj, and you had 9 UBOs. There was no formal documentation with respect to the ownership stakes of those UBOs. The same thing applied in Odyssey. You had two beneficial owners. Mr. Araj owned an offshore company which had 49%, and then one of his best friends, who was an Emirati, owned 51%. He was required because it was on the mainland, and he required a sponsor, but ultimately Ezelddine was the beneficial owner. But there were 4 UBOs, and the same thing applied. There was no formal documentation supporting that. We had always worked on the basis of trust for many, many years. That's just how the relationship was and how it operated.
But you weren't close to Mr. ALMHEIRI, were you? I mean, there's no emails between the two of you in this before the court, at least.
I was not terribly close to him. I met him, I don't know, maybe a dozen times over the years, traveled with him once.
I mean, no real trust between you and Mr. ALMHEIRI. You weren't close to him, were you?
I never met Mr. ALMHEIRI in person.
All right. So if I could take you to a document, a D39553, you just pull that up on the screen. Do you have that?
Yeah, but it's in very small font. If you could put it on the screen, it would be helpful.
Well, hopefully it'll appear soon. We're looking at D39, page 553. Let me know if you can't read this. I'll read it out to try and make it easier for you. There's an email.
It just came up now.
Okay, great. Thank you. There's an email from you to Mr. Dazi from the 30th of September 2014. You can see it's in response to an email from ALMHEIRI, where ALMHEIRI have been approached to provide a fee proposal, and they're writing back about that. And there's a reference there to what's being proposed in relation to QMB. And then you say, in response to Mr. Dazi copying Mr. Araj, we don't want KHALED to hold the purchase option in his name or a company controlled by him. It should be with Ezelddine or another SPV we control, as discussed previously. Now, it's been said on your behalf that this shows that some representation has been made to you. But the point I'm going to make is, firstly, that contradicts what you've already told the court, that actually you didn't think you were going to get your 50% until the QMB loan was being repaid. So this doesn't actually help your case, does it?
Well, what I said to you was we were going to receive collectively 50% as soon as HSBC debt was retired, and then the remaining 50% once the QMB loan was repaid.
Right. But this is not saying that. In other words, this email is not in support of what you've told us today.
Well, I think this email is referencing the purchase option agreement or agreements that were to be put in place between ECL and Odyssey, EVL and GSS.
Right, so something different. If you actually look what you say in your email, you say, can we avoid the option altogether if the shareholders agree to a recapitalization? And then Mr. Dazi replies on the same day, John, I don't want to renegotiate with bank now. What I'm going to do is make an option, but only for 1 year, and trying to make to a corporate entity. So he's basically saying, look, I'm not going to go down this route right now. So in other words, you knew that this particular document, what you're suggesting here, wasn't going to be implemented.
I'd have to read the entire, I don't know.
Okay.
I'd have to read the whole thing to understand the context, like from beginning to end of the trial.
Right. Well, I'll leave it to your counsel. Of course, your counsel can come and invite you to answer further questions about this, but I'll leave that for now. If I can now ask you to go to page 561.
Okay.
I'm just showing you this email just to show you that Mr. Nejar, he works with Mr. Dazi, right? He worked with Mr. Dazi.
Yes, correct.
And you can just see what he's doing in that email of October 28th. He's writing to HSBC. So this is back in 2014. And he's saying, it's my client's opinion that HSBC and banks usually take the lead for such type of transaction. He's attempting to negotiate with HSBC, but on behalf of the companies, right? GSS and Odyssey.
No, actually, he's clearly referencing EV, which he means EVL. It was quite surprising. If you read the second sentence, it was quite surprising to EV that HSBC did not EV.
Okay, fair enough. Fair. I understand. Now, if you then look, like he's basically informing you, he's keeping you informed. You can see that on the top email. He's sending this to you and Mr. Araj.
There's a reason for this, if I may. As I mentioned earlier, Ezelddine and I were basically dealing with HSBC's workout department for the years leading up to this. So while Manil was negotiating with them, Ezelddine and I on the other side were still meeting with HSBC. There was like a Chinese wall. HSBC didn't share with us any communications that they had with Manil representing Ezelddine. And we were still in contact with HSBC. So we were basically giving each other feedback, what Ezelddine and I were hearing from HSBC during this negotiating period. And Manil would share with us what he was hearing from the other side, which was at a higher level as he was trying to negotiate the purchase of the debt.
Yeah. Okay. But before moving off this topic, I just want to ask you a question. The other UBOs in GSS surely would have an interest in GSS's assets. So the question I'd like to ask you that you suggested that you were going to get 25% interest and then a 50% interest once the QNB loan was paid back. That surely would be subject to agreement with the other UBOs who also have a beneficial interest in the company and therefore indirectly the assets. Go ahead.
As KHALED mentioned in one of his submissions, and I think in one of mine as well, at that juncture, at that point in time, all of them just want to have the guarantees released and move on. The company struggled for many reasons. If I had 1 minute, I'll just explain a couple of things that happened. Of course, we started right around the recession. The factory was ready to go around the end of 2009, and we had to have power connected. If you recall, if you lived in UAE at the time, there was a massive power shortage. Long story short, we didn't get connected power until middle or third quarter of 2012. So the company sat idle for these years without power, and we defaulted. So HSBC withdrew our working capital. So all the UBOs were underwater and just wanted to escape the liability and get out of it and move on. And they were happy to do so. No one else showed interest in wanting to participate in any way going forward.
I'm going to now move on to a different topic. My lord, I don't know whether now's a good time to have a break, if you wish, because I'm going to start a new topic.
Yeah, it's earlier than your program.
Yeah,
So
I'm in your hands. I would say I'm halfway, so I can continue a little bit longer.
why don't we go on for at least another quarter of an hour, maybe 20 minutes? Mr. Cameron, are you happy to carry on for a moment, or do you need a break?
I'm fine, Your Honor.
Let's carry on for another 20 to 30 minutes.
Yes, I'll continue. So I want to move to the topic of the alleged promise in relation to Mr. Almehiri signing the guarantee. Let's look at what you state in your second witness statement. If we can go to C13, page 266.
C13.
And I'm looking at paragraph 9. You say, I signed the D2 agreement on the basis of what I was told by Mr. Dazi and Mr. Araj at the time, the details of which I set out further below. So, in relation to this alleged representation, are you saying that Mr. Dazi and Mr. Araj told you that Mr. Almehiri would sign a guarantee?
I believe at that time, I'm not sure if they told me he had already signed or if he was going to sign. Well, I was told that the guarantees that were signed by all three of us were executed more or less at the same time.
Let's just back up a little bit. When do you say you were told that Mr. Almehiri would sign a guarantee? Not when he did, but when he would.
I can't recall the exact date. In advance of whatever date it was that I signed my guarantee. Well, in advance. I can't recall the exact date.
Okay. And indeed, you don't say that in this statement. And in fact, the place that you deal with this is at paragraph 43. So on page 271, if you just scroll down a little bit. You talk about, so from me, there's a section headed Mr. Al-Mahdi's guarantee. But actually, there's nothing in these paragraphs where you explain what you're told by Mr. Dazi and Mr. Araj. And so the point I'll put to you is that, in fact, you weren't told anything by them at all.
Well, that's your opinion. You're welcome to have it.
Well, when were you told by each of them? I mean, I've dealt with that, so perhaps you don't need to, unless you've got anything to add to that.
I've already
You
answered
don't
it.
need-
Yeah, that I don't know the exact date, but it was definitely well in advance of the date that I executed my indemnity.
Let's take Mr. Araj. When did he tell you? Sorry, not when. How did he tell you that?
It's similar to the.
indemnity?
I understand. It's similar to the discussion we had with respect to the leases and when did I know and so on. At the onset, when the plan was put together by Mr. Dazi, everything was laid out. From that point onward, the framework was known and understood by all involved. And, you know, through the many discussions that were held and meetings that were held, from time to time, these issues would always be raised. Not always, but from time to time be raised. So it was not like it was something that was hidden in the closet and every now and then it was pulled out or it was pulled out just before I signed. It was always known. It was always part of what was agreed to from the onset and understood.
You're saying it was always known and understood. Just to be clear, you're not suggesting that anyone's actually out to trick you, are you?
I'm suggesting that I was told what I already mentioned to you with respect to the indemnities anyways, that there would be two others signed along with mine, one from Mr. Al-Raj and one from Mr. Ahmadi.
But are you, I'm asking you a slightly different question. Are you also saying that Mr. Araj and Mr. Dazi were out to trick you in relation to that?
Well, I didn't say that.
Well, is your answer no then? You're not saying that they're trying to trick you?
Mr. Bohr, if you want to point to somewhere where the witness says that, I think it's fair to the witness that you show him.
Yes. My Lord, Mr. Cameron.
Yes.
What's being alleged on your behalf is deceit. So it's being alleged that Mr. Dazi and Mr. Araj deceived you in the representations and each of the representations that were made. And so I'm simply asking whether you are also accepting that. That's the statements being made on your behalf. Are you saying that they were out to deceive you?
Okay, you're referring to the legal arguments or precedents that my lawyers have raised in my submissions? Where
that's right.
Okay.
Again, just to be clear, so I don't put you on the spot, to just make sure you understand.
Yeah,
they're saying.
I agree to what they have alleged stated in my submissions.
Okay. Now, when Mr. Dazi and Mr. Araj told you that Mr. Al-Mahdi would be signing an indemnity or guarantee, something to that effect, were they together when they told you this? Or did each one do it separately?
I can't recall.
Mr. ALMHEIRI says that you would have been told that Mr. Al-Mahdi would not be giving indemnity. He said that you would have been told that.
Yeah, I saw that. That's definitely was not the case.
Okay. So we'll have to disagree on that. If I can now ask you to look at tab C15, page 287.
287, okay. Okay. No way, could be.
You refer to this point that I just mentioned before. It's paragraph 33. You say, Mr. Araj claims that you never mentioned anything about Mr. Al-Mahdi signing a guarantee. I already knew that Mr. Ahmadi would not be signing it. I do not recall Mr. ALMHEIRI himself telling me about Al-Mahdi's guarantee. So you accept that Mr. ALMHEIRI himself never told you anything?
I didn't, as I mentioned to you, all communications were funneled through Mr. Dazi.
And then what you do in your witness statement is you refer to various emails, true emails, and I think you may have mentioned them today too. But let's just look at those. There's one at D32, page 538. Sorry, mine's quite large, I'm just shrinking it. So there's an email you can see of the 5th of July sent by Mr. Dazi to you, Mr. Araj. And it started, Dear Khaled and Khaled. So
Yes.
Khaled and Khaled is Mr. Ahmadi and Mr. ALMHEIRI, correct?
Khaled would be Mr. Al-Muhari and Mr. Al-Mahdi's brother. His name was Khaled. And Mr. Ahmadi's brother was also involved in the discussions with
Okay.
So you see, if you go to paragraph 2, he refers to him as Khaled Ahmadi.
Right, thank you. That's helpful clarification. So the email is being sent from Mr. Dazi to you and Mr. Araj, but it's being addressed to Khaled and Khaled. So is it right that what this is an email that Mr. Dazi intends to send to Khaled and Khaled, and he wants to run it by you and Mr. Araj first? Isn't that what's happening here?
Could you scroll down so I can see the full email, please? Okay, this is one of the emails I was referring to earlier, where he outlines the steps. So so I mean, he would need to have Ezelddine on site here, because in order for this to come together, there had to be cooperation from GSS, and Ezelddine was the beneficial owner of GSS. So I guess what he's asking is this in line with what we've discussed and agreed to?
Okay, but just to focus on my question very specifically, what I'm suggesting is that Mr. Dazi is sending you a draft email and wants your input into this, because he's not writing to you, even though it's being sent to you. It starts off, Dear Khaled and Khaled, and vice versa. It's a joke.
Yeah, I understand that. I understand. And my answer is what I just said. Yeah.
Yeah.
I believe he wanted to make sure that Ezelddine, well, GSS, was on side with this, because there were requirements, steps or actions that GSS had to take for this to work.
Right. And you can see that there's an email above from Mr. Araj where he just says it's okay. So he's giving the approval for this email to be sent.
Yeah. Also, if you look at paragraph 2, you can see where Khaled Ahmadi refers to a guarantee coming from his brother. Yeah.
Absolutely. We'll look at that. But I mean, before we get to that, I just wanted to establish that actually it's an email that's going outward from Mr. Dazi, not inward to you. It's not a representation to you. It's an email that you are approving, or rather Mr. Araj is approving expressly. You're approving.
As I've just said twice now, I believe that I mean, I don't know, I can't speak for Mahdi, but just looking at it, I would assume that he wanted to make sure that Ezelddine was in agreement with the contemplated structure outlined here, because it required certain actions from GSS, which Ezelddine controlled. That's all I can, that's what I think, what my belief is.
Well, I've heard your evidence. So you mentioned of the email, so let's look at that. And this is all important for you, I imagine. You said the loan will be guaranteed by the SPV, and after the transaction of the company, and it was suggested by Khaled Ahmadi Ali or his company will guarantee the personal guarantee to Khaled, as it is going to be a personal loan to Khaled Meher in the first place. So there's a suggestion here, isn't there, that actually Mr. Meher is going to take out a personal loan. I mean, we know that he did do that. There's a suggestion here that Khaled Ali or Ali or his company, they'll provide a guarantee for the personal guarantee of Mr. ALMHEIRI.
Well, no, it doesn't say Khaled Meher or it says Ali or his company.
Right.
Ali references Ali Ahmad. Yeah.
But the point that I understand that you would like to take from this is that it shows or it supports your allegation that there's a representation in relation to Mr. Al-Mahdi providing a guarantee. That's what you would like to take from this, correct?
Well, I'm just, it is what it is. As it reads in paragraph 2, it's pretty clear. So subsequent to this email was sent in July 2014, things moved forward. So I presume that Khaled Ahmadi, for that matter, was on side with this. And then for him
well,
to be on side.
Let's take it in stages. Firstly, I want to highlight the word suggested. Suggested is quite vague, isn't it? There's nothing set in stone, is there? It's just a discussion that's being proposed.
Where does it say suggested?
In that paragraph, it says as in the second line, as it was suggested by Khaled Ahmadi.
Yeah, I think there's another email where
we'll get to the other email. We'll get to that.
Yeah,
if we just focus on this for the moment.
Mr. Ball, if the witness wants to just let him finish what he's saying, by all means move on to it. Move on from it.
I apologize, Mr. Cameron. Please continue.
I was just going to say, I believe there's another email prior to this where Mahdi is emailing Khaled Al-Mahdi and he lays out the plan and Khaled Al-Mahdi responds saying, I like it, or something to that effect. And then I'm guessing this is subsequent to that email.
Right. Well, I don't recall that email, but no doubt you'll count.
It's in one of these document packs.
Okay. The point that I made is that on the basis of just this paragraph, nothing is set in stone, is it? It's just a suggestion, and it's a suggestion that looks like made by Mr. Al-Mahdi, but that's as far as it goes.
Your Honor, I believe the witness has answered the question several times now.
Yes, well, we tend to allow a certain leeway to people asking questions, but I take your point.
Okay, well, in that case, I'll move on. I think I accept this. So paragraph 6 of this email, it says it is important to note that the inception of all of this, Khaled Meher did tell me that he would not put his personal guarantees, and it's paramount that if formally he has to have one because it is a personal loan, Khaled, a guarantee has to have no legal bearing or has to be 100% backed. So you understood that actually there would be no risk to Mr. Al-Mahiri. He was not willing to take any risk for this personal loan, was he?
Well, as it's written here, we understood and it was made clear to us that Khaled wanted our guarantees, yes.
Now, this email is from July 2014. So it's over a year before the indemnity agreements were signed. So is it correct that after this email was sent, Mr. Al-Mahdi refused to give the guarantee and you and Mr. Araj stepped into the breach? That's just what happened in the intervening year and more.
Well, earlier you asked me the question with respect to the timing. This gives you an indication because they're discussing the guarantee for Mr. Al-Mahdi in this particular email. But I did not learn that Mr. Al-Mahdi did not provide his guarantee or indemnity, until the fall of 2017, when it was disclosed to me from Benil while I visited him in Paris. As far as Ezelddine is concerned, I was led to believe that he provided his indemnity, just as I was led to believe that he provided his security check. I only found out that he didn't provide his security check after the fact in late October 16. And I don't think I learned about the indemnity until KHALED filed, or until maybe Manil told me as well in 17 when I visited him in Paris. I wasn't aware that these two indemnities were not in place with KHALED.
One notable absence of in this email is that there's no mention of you and Mr. Araj providing a guarantee. Can you tell us when you were asked to provide a guarantee? Or, sorry, or an indemnity, more accurately?
Well, you've asked me that multiple times now, and I told you I can't remember the exact timing. I believe it is around the period of time that Dazi designed the structure that he recommended going forward with. And as the pieces came together, and Ezelddine and I decided that we would like to continue on under certain conditions and circumstances, it would have all been discussed at that time. I don't know the exact date. This email itself and the date of the email and the fact that they referred to a guarantee, it's maybe before this or around this time. I can't recall the exact date, but it was always part of the overall contemplated macro structure of the whole transaction and how we got from A to B. So like I said, it wasn't something that was hidden in the closet. It was always discussed openly. It was part of what we're trying to accomplish.
It comes to now then to document at page 586. It's tab D43, page 586.
Mr. Bohr, I don't want to interrupt you, but we're coming roughly in time with the program again. So yes. Anytime you want to stop for a break, please say so.
My lord, I'm going to stop now in that case. I'll just leave this on the screen and we can come back to it. It's fair. That's a good place to stop.
It's very well. We'll take 15 minutes. Mr. Cameron, can I ask you not to talk about the case in the meantime?
Sure.
And we'll come back in 15 minutes. So please feel free to go and get a coffee or something.
Thank you.
Thank you. Yes, thank you. Is everyone present who needs to be?
On our side, yes.
Yes. Mr. Bohr, then, when you're ready.
I'm ready.
So I should say, welcome back, Mr. Cameron.
Thank you, Your Honor.
Welcome back, Mr. Cameron. There's a document on the screen, 586, page 586, which I just left on the screen before we had a break. This is one of the emails that you want to rely upon in relation to the Mr. Al-Mahdi guarantee allegation. Do you recall that?
Yes.
So the email is from May 2015 from Mr. Dazi to you, Mr. Araj, and it says, here's the document that everybody needs to date and sign. Also put your exact name and passport number by blue pen. Scan it and send it back to me. And if we scroll down, we see that this looks like an indemnity, but it's in draft form. There's no names in there. There's a few blank spaces. So I just want to understand the background to this document. Firstly, it's the correct attachment, is it? This is the correct attachment to the document because it doesn't refer in the actual email to a draft indemnity. But as far as you recall, it's the correct attachment?
I don't know.
On that, you provided the document, this document, I assume, to your lawyers.
This particular version of the document, I don't know if this is the final document that or the final version that I ended up executing or not.
Just to be clear, then your evidence, as I just heard it, is that you're not 100% sure that the document that follows on from this at 587 onwards is the attachment that's being referred to here. Is that
no?
correct?
I mean, I don't know if it's detached or not. And to determine whether or not that is the exact same form of the agreement I signed, I'd have to, compare that to what I signed.
Yeah, that's not my question, Mr. Cameron.
Okay.
I simply want to make sure that this is the attachment. The reason I'm asking, just to be clear, is because the email itself doesn't say, please find attached a draft indemnity.
I see. Well, if
So
you
it
have
doesn't,
the
it
email,
doesn't,
if you
Yeah,
have
well,
the email, then I presume you'd have whatever was attached to it.
I understand. We can follow that up if necessary. But looking then at the contents of the email, here is the document everybody needs to sign. So do you recall at this point in time that what Mr. Dazzy was saying is that everybody, when he says everybody, does he mean all the UBOs?
Well, I think it's pretty clear he means myself as the dean and Mr. Ahmadi.
Right. Well, I'm not sure about that. The reason is because if you look at the next line, it says, I let you transfer it to the others. I will send to Ali. So I assume Ali is Ali El-Ahmadi, correct?
Yeah, that's what I assume as well.
Right. So on this basis, it looks like what he's saying is he'll send to Mr. Al-Ahmadi, I let you transfer to the others, suggesting that there are other people he wants this document sent to in addition to Mr. Al-Ahmadi. Would you agree with that?
No, I mean, his statement is an odd one. You're correct. But it was never, ever contemplated that anyone other than the three of us would be entering into indemnity agreements or guarantees for KHALED. So I'm really not sure what he means by that.
Understood. Well, maybe, and this is just a suggestion, and I'll be interested in your reaction, maybe he just wants everyone to understand what's going on. So he wants this sent to the others. He wants Ali to understand what's going on. He wants everyone to understand what's going on.
As I mentioned to you previously, the persons involved at that juncture were Mr. MUSABEH, Mehdi Dazi, Manil Najjar, Ezelddine Araj, and myself. There was no one else. So perhaps he's referring to sending to KHALED and to Manil. That's a possibility.
Very well. We looked at the document that we think is attached to this, and as I said, it's in draft. It is correct, isn't it, that there's still negotiations to be had around this document?
At that time, I don't know.
Well, we saw an email, I think it was from the 25th of, oh no, maybe, yes, I think it was later than this. I'm actually hesitant because I'm not sure, I can't quite remember whether it was this year or not. No, it wasn't. Okay, so scrap that question. After this point, this email was sent, you didn't check with Mr. Al-Mahdi that he would sign this document, did you?
I've already told you that I have never had any discussion, nor have I ever met Mr. Ahmadi.
Right. Can we go to C13, page 271?
Yeah. 13, you said? 1-3?
Yes, C13, page 271, which is your second witness statement. And I just want to look at paragraph 43. This is a point that you raised earlier. You talked about your reason for wanting Mr. Al-Mahdi's guarantee.
Okay.
You say he was a Qatari minister. You want to have the benefit of that same deterrence, especially considering that Mr. Al-Mahdi was also the chairman of QMB. In other words, what you're saying here is you wanted him to sign the guarantee because you felt if he did, then QMB wouldn't pursue anyone in relation to this loan because you'd have the chairman.
I believe I go on to state that in the event that we, were late on a payment or we defaulted, we would have the ability to restructure because they certainly wouldn't want to take action against Mr. Ahmadi.
Right. So the first point is that they wouldn't need to take action against Mr. Al-Mahdi, would they? Because they would have guarantees on your version of events from 3 different people guaranteeing the entire debt. They could simply pursue you.
Well, they would have the guarantees from three people, but more importantly, one of those persons was the chairman of the bank and the finance minister of the country. So do you really think there's any even 1% chance that they would take any action? They certainly wouldn't. Similar to the situation we have with HSBC, but more so in this case because he was the chairman of the bank. At least that was my perception, and that's what I believed. And I think anyone looking from outside would have a similar thought process.
Right. Well, I understand that's your perception, and then of course we contest that. You mentioned HSBC. The point is, you thought the same about HSBC, didn't you? You didn't think HSBC would pursue you either, because one of the UBOs, well,
if I recall correctly, I mentioned to you that in numerous meetings with HSBC, they made it clear to us that they would not in any way pursue Mr. Ahmadi for obvious reasons, and that they want to find a solution. They desperately want to find a solution. Along with the debtors, they too want to find a solution. And that's why they ultimately ended up, in my opinion, taking or offering such a large discount on the debt. They just wanted it to go away for that reason.
Right. Well, isn't the truth that you were confident that QNB wouldn't call in the loan because Mr. Ahmadi was chairman of QNB? It had nothing to do with the indemnity. You were simply confident that because he was involved, because QNB were extending the loan, they were going to be taking action, which is why you took the risk.
Don't you think the chairman, knowing that he had an indemnity in place, would make certain that that event never occurred? Of course he would. We take steps to make sure that didn't happen.
The point I'm asking you, Mr. Cameron, is that it wouldn't matter whether you signed the indemnity or not. Even without that, you'd still be the chairman of QNB. And without that, you would have believed that actually QNB wouldn't be taking any action, just like you did with HSBC.
No, in the case of in the case of HSBC, Mr. Ahmadi was one of the guarantors.
Right, and in the case of this QNB loan, Mr. Ahmadi was the chairman of QNB. He was still a UBO.
Yes, correct.
That would be sufficient.
Correct, and I was also told that he was a guarantor and that he had signed an indemnity along with myself and Mr. Araj, which I've now repeated maybe a half dozen times.
And the point that I'm making to you, and I'll put it just one more time, is that even without him being a guarantor, you would have believed that QNB wouldn't be keen to pursue this.
No, why would I believe that? If Mr. Mahdi was not involved in any way in the business and if he was not an owner of the company, and if he did not have a guarantee in place, why would that be? That would not necessarily be the case. Why do you say that? Why would Mr. Ahmadi ensure that the other parties were protected if he had no skin in the game, if he had no liability or exposure? What motivation would he have? Because he was friends with Cal? Maybe.
Well, Mr. Ahmadi was UBO, remained a beneficial owner of GSS and Odyssey, didn't he?
As I said, once the HSBC debt was retired, basically all the UBOs walked away. They all want to exit the business. And of course, also at that point in time, he was released from HSBC along with the 8 others.
Let's move on to the question of the security check. In addition to the indemnity agreement, you provided a security check for the entire amount of the QNB loan, didn't you?
I provided a security check to backstop my indemnity agreement, yes.
And that was, just to be clear, that was for the entire amount of the QNB loan.
Yeah, I believe it was equal to whatever that was, yes, in dirhams.
And so we could assume that you had that money available, 92 million AED.
I wish I had this. I did not have 92 million dirhams available to me at that time.
So you wrote the check without that being available?
It was a security check, and my understanding was that the reason why it was 92 million because it was an amount that the value of the check had to be to an amount reaching the ceiling of the debt obligation that Ezelddine had with QNB. If for whatever reason we failed to perform, in other words, the lease agreements were not able to service the Ezelddine debt, and in other words, the guarantee or indemnity failed to perform, then I would be on the hook for whatever that amount was, up to worst case scenario, if, you know, all hell broke loose, a maximum of the value of the debt, the total debt.
And did you accept that the check should have been in the name of Mr. ALMHEIRI? That was the intention.
Well, I received, I was told two things, actually. One, Mr. Dazi told me to issue it in Abdul Aziz Dazi's name because he was the owner of the two Eladis. And then there was an email from KHALED's lawyer, Baker McKenzie, stating to write the check in the name of Abdul Aziz Dazi. And I think that email is in Way's packets here.
So just to rephrase my question slightly, would your expectation have been that it should have been in the name of Mr. ALMHEIRI?
I had no expectation. I basically issued it where I was told to issue it. To whom, I mean, I was told to issue it.
And when did you provide this check? What was the date that you provided it? I mean, you may not be able to remember the specific day.
It's actually referenced in one of your the date that there's an email that was sent to me from Ezelldine with a copy of his check.
Yes. And that doesn't tell it. Let's go to that. It's a D60, page 922. I think this is what you're referring to. Tell me if that's not the case.
Yeah, so that was the date. Are you there? Okay. That, I believe that is the date that I issued the check.
Yes. And so this was, do you think, according to your recollection, you issued it around this date, around the 28th of January?
I'm pretty sure it was the exact same date. And then I had my driver drop it off to Ezelldine, or maybe to Ezeldine's driver. And then Ezelldine had it sent over to the hotel where Manil Najjar was staying in Dubai.
Do you have a copy of the check?
I have a photocopy of it, yeah. So, I mean, I think we all have.
Would you be prepared to provide that to your lawyers so we can see what date it was?
I'm sorry, can you repeat that?
Would you be prepared to provide the copy of the check so we can see what date it was issued?
I'd have to take advice of my lawyer.
Of course, of course. Okay, we'll follow up on that. Presumably, this January of 2016, of course, quite a long time after the indemnity agreement was signed. So presumably at this time, you knew certainly that you had no shares. That's one of your complaints, that you felt that you were entitled to shares within EVL, ECL. By this time, you knew you hadn't received any, correct?
You froze for a second. Let me just read the transcript.
Let me repeat that question.
Okay.
I repeat it. You can hear me now, okay?
Yeah, I hear you now.
Yeah, okay. So the question I was asking is, presumably by January 2016, you knew that you hadn't received shares in EVL or ECL, as you say was promised to you.
Correct.
So that obviously couldn't have been a concern to you because you just handed over a check for the entire amount of the QMB loan. So when you did that, you obviously didn't have an issue with not having any shares at that point.
The check of the QMB loan that you're referring to, January 28, 16. Oh, that's January 16. That was in January 16. Sorry.
Yes.
Yes. Yeah.
I'll repeat my question if it confused you.
Yeah.
When you signed the check, you knew that you did not have the 25% of the shares in EVL ECL, which you claim were promised to you. Correct?
Do you know the date that the HSBC debt was paid out?
I don't know that date offhand. Is that because you're saying you were only going to get the 25% when that was done?
Yeah, they as I explained previously, they want to conclude the whole transaction, and afterwards the shares were to be transferred to myself and to Ezelldine as a discussion.
The problem, Mr. Cameron, is that comment about the HSBC debt isn't in your evidence. It's something that you come up with today in terms of when you were meant to receive the 25%. So that's the difficulty that we face. Let me ask you another question in relation to this. You knew when you gave this check in 2016 that there were no equipment leases in place, correct?
But the equipment leases, as you pointed out many times during our discussion, were to be put in place as post-closing conditions. And if I may go back to what you just said concerning the check, sorry, let me just read the transcript. Okay. As I mentioned to you earlier, and it makes perfect sense and it's logical, it was explained to me by Mr. Dazi and Manil Najar, for that matter, that Ezelddine could not be shown to be in the licenses of the two lotties until they concluded with HSBC. Otherwise, HSBC would read the constitutional documents and see that two of the shareholders were also amongst the debtors that were being bailed out. And that's why we were initially not placed on the license.
Mr. At this point in January 2016, you would have also known that Mr. Almehiri hadn't provided an indemnity, correct?
No.
You didn't know.
No, I did not.
Now, Mr. Araj says he learned about this at the end of in August 2015.
I saw
Mr.
that.
Araj, and he witnessed your indemnity signature, didn't he?
Yes, he did.
So surely he would have discussed with you the issue around Mr. Almehiri, given that you both said that was an issue for you.
I would have thought so, but at the same time, he also told me he had delivered his check and his indemnity, and he did neither of those as well.
Do you say that Mr. Araj also misled you in relation to Mr. Almehiri's indemnity?
Mr. Araj didn't even discuss it with me, so I always assumed it was in place. It wasn't Mr. Araj that told me it was not provided. It was Mr. Najar who eventually outlined everything that had transpired, and amongst the various issues he shared with me was that there was never an indemnity from Mr. Almehiri, and that was in November 2017.
My question was slightly different. My question was, did Mr. Araj mislead you when he said that Mr. Almehiri will give an indemnity? You know, there's not what happened, but what would happen.
Well,
is that your case?
It was Maddie Dazi that was telling us, and even from the communications that we shared together on the screen here, it was Maddie Dazi that was tasked with and was telling us that, you know, the indemnity, he was bringing us the indemnity, indemnity for Mr. Almehiri, and it really wasn't Ezelddine's job to obtain that.
Right. Well,
what he knew or discussed between himself and Maddie Dazi, I don't know.
Right. Well, your pleadings say something different, Mr. Cameron, but we'll leave it there. Now, you got this check back, didn't you?
No, I didn't.
So, according to you, then, Mr. Dazi still has your check?
I don't know who has my check because it seems everybody is denying they have it. There was a letter sent to me from Baker McKenzie at one point in time where they referenced that they were in possession of or had control of my check. But since then, it's been evident in your filings that KHALED doesn't have the check, and I guess the Dazis are saying they don't have the check, and nobody knows where the check is. But I certainly don't have it.
Well, we've heard your evidence on that. It doesn't. We'll have something to say about that, but I'm going to move on. Just focusing on Mr. Najar, you mentioned a short while ago. He was a banking consultant, wasn't he? And
I think he's been in the investment banking field for a number of years. Various banks. I think he worked for EIC in Abu Dhabi. I think he worked under Maddie Dazi at the time. But basically, he's from the financial community.
Yeah. And he was assisting Mr. Dazzy in the restructuring.
Yes.
If we can take you to the document at D31 at 536.
Okay.
You can see that. Bear with me 1 second.
I see it.
Yeah. A sec. Right. 536. There's an email from the 6th of May from Mr. Nedjar to HSBC, where he talks about himself, he's transitioning out of emerging capital markets. And he said one of these opportunities is UAE-based Gulf Steel Strands, and it turns out this company is heavily leveraged, with HSBC being its sole lender, in order to be able to present an offer to GSS's shareholders. So he's representing here, he's told himself I was representing GSS's shareholders, isn't he?
Well, he's stating that he is. It doesn't necessarily mean.
Yeah. Okay, well that's what he's stating, fair enough. And if you go up to page 534, he's doing something similar here as well, isn't he? When he's interacting with HSBC, he's saying, "Dear Aaron, as per our meeting and our follow-up conversation, the investors have expressed an interest in acquiring both Gulf Steel Strands and Precision." So here he's acting for the investors of GSS
Sure.
and Odyssey.
And the investors are EVL.
Well, that's
Does he
not
specify
correct.
here who the investors are? No, he doesn't. But we know he was acting on behalf of EVL and ended up contracting with HSBC on behalf of EVL.
Well, we know that, but this is 2014. So this is prior to the whole QMB situation and EVL ECL. Or am I wrong about that? Isn't he suggesting that there's the investors? The investors are the UBOs, aren't they?
No, they're not.
Okay, well, you disagree with that. Fair enough. At D31, page 533.
No. Okay, it's right here.
Mr. Nedjar's right or forwarding to you the communication with HSBC. You can see there's an email from the 5th of June.
Yeah.
So to you and Mr. Araj, I think we can be cautiously optimistic considering the speed and the context of their reply. So he's saying we can be cautiously optimistic. He's basically saying, but we're in this together. He's representing. It's the point I'm making before. He's representing you in addition to the other UBOs, isn't he?
Once again, he's not. You know who the persons involved are because I've mentioned them multiple times. It's myself. In terms of the 4 players involved in the company and the ownership stake and the debt and so on, it was KHALED, it was Mr. Ahmadi, myself, and Ezelddine, and the 2 people who were spearheading the negotiations with QNB and HSBC were Manil and Mehdi Dazi.
Right, and so he's acting on behalf of all of you, correct?
Well, as I said, there was a global structure agreement we were putting together, and of course, we all wanted him to succeed. On one side of the equation with HSBC, as Dean and I were going there 2-3 times a week through the workout department, and the other end of the spectrum, Neil was doing his thing with whoever this individual was at the higher level, trying to negotiate. So, as I said, we all want to come together for our collective interest. It's no secret here. It is what it is.
I'm going to look down at the memorandum that Mr. Nedjar produced and sent to you. Just before doing that, if I can ask you to go to document D96 at page 1184.
Sorry, can you repeat the page number, please?
Yes, it's 1184. 84. So if you just scroll down a little bit, you can see there's an email there from Mr. Nedjar to Mr. Almadi and Mr. Maheri and to Mehdi Dazi. And it's an email of complaint. And there's a whole list of things that Mr. Neja once, this is now 2017. Is it right to say that relations are broken down between Mr. Neja and the people he's sending this email to?
Well, he had definitely broken down between Mr. Najjar and Mr. Dazi. I don't know if he was still in contact with Mr. ALMHEIRI at the time or not. I don't know.
Fair enough. If we go back up again to the email that was then sent to you on the 27th of October, Mr. Neja is writing just to you this time, explaining, he said, for your information. So he's forwarding this email and he's saying it's very humiliating, please see below, the obvious evidence that I'm on my own from now on, without the guru in between. By guru, I assume he's meaning Mr. Mehdi.
Yeah, I'm pretty sure that's what he means.
He says, I think I can make it happen like I did all the rest. And so he's confiding in you, isn't he?
Well, what had, I believe, and I'd have to look back through my notes, I was also looking for solutions. And I had found a potential investor. And as I said, I'm not from the financial community, so I needed, and since Manil was already familiar with everyone at QNB, I was looking for somebody who could maybe help me put it together. And where he says, I think I can make it happen like I did for all the rest, I think he's responding to my discussion with him, where I asked him, or when I asked him, would he be willing to consider helping us negotiate with QNB if I can bring an investor on board.
Very well. If I can then go to D981188, which is the memo which follows later.
Okay.
Next year.
Sorry, Harris.
1188. Okay.
Which page, Harris?
1188. Yeah, so this is the memorandum that I mentioned before. So this is the memorandum that you would wish to rely upon, correct?
It is one of many documents we've submitted.
Well, it's slightly more than that. Just to be clear, your lawyers put in a hearsay notice, and they seem to want to rely on some of this memorandum. We'll go through this. You don't need to answer my question, Araj. So I'm going to ask you specific points about it. The first question I'm going to ask you is: it's right that this memorandum is being sent to you.
Yes.
It's for your benefit.
Well, I mean, it summarizes what, in Manil's opinion, occurred throughout the period in question, what transpired in the question, with respect to specific things.
Right. Well, you say it summarizes Mr. Manil's opinion, but it's an opinion that's based on discussions with you?
Well, Manil was the right-hand man of Mehdi Dazi throughout all of this, and he was really the what's the term? He was in the center of everything. He's the one who negotiated with both HSBC, and he's the one who negotiated with QNB. He was interacting with all parties involved in the transaction, so he was, the center of the universe for this transaction. So Manil, more than anyone else, had an understanding of, the big picture and where everyone fit into the puzzle.
But again, some of what Mr. Neja is discussing in this memorandum would have come out of discussions that you had with him about events that took place.
Well, what happened was I actually flew to Paris in the autumn of 2017. And at that time, he had a falling out with Mehdi. And I think if you go back to the previous slide you showed me, and around that time, he said maybe he can help me. And he told me the whole story. And when I learned, what had occurred, I asked him, can you document this? Because, this is all news to me. These are serious revelations. And can you put this in writing? And he, later on, he agreed to do it. I mean, I asked him to do it, obviously much after my meeting with him, but he did it.
Is your concern around this time is mainly the check, isn't it? You're worried about, there's a check out there.
Yes, that's right.
Signed. Sorry, Mr. Cameron?
That's correct.
Yeah, and so that's your main concern in relation to this.
Right.
Yeah. If I can take you to D99 and page 1195. This is an email exchange between you and Mr. Nedja
Okay.
from the same period that the memo is being produced. And you can see on the 12th of July, he says, "Hi, John, please find attached the revised version of the memo for your review." So that looks like there was a prior version that perhaps you commented on.
That's very good. Yeah, I guess there was. Yes, obviously.
Yeah. And then you then respond later on that day and you say, "It looks pretty good. I made a few minor changes for your review." And then you talk about elaborating further on the role you play with respect to overseeing the entire process. So there's a few points that arise from that. Firstly, you're suggesting changes to the memorandum. We can agree on that. Is that correct?
Excuse me. I'm mixing. Well, no, he's asking me. In other words, have I covered, everything that, you're looking for? And I knew he had all the knowledge, as I just said to you. So I want him to expand upon it because he knew everything that occurred from A to Z. So I wanted him to add more detail. Very simply put.
Yeah. And you also talk about the other point I wanted to flag up is you said on the role you played with respect to overseeing the entire process. Well, I think. And again, I know I've asked this question. Mm-hmm. I've asked this question numerous times, but the point is that that's his role. He's not just acting for Mr. ALMHEIRI in any specific way.
He's working for Mr. Dazi. He's working for Mr. Dazi.
I understand.
And by the way, he had worked for Mr. Dazi or together with him multiple times over the years. It was not a new relationship. They had together had a long-standing relationship.
Yes. Mr. Cameron, by the way, as I'm asking questions, we've started getting in that habit of talking over each other again. I'm going to try my best not to do that to you. But if you could just wait till I finish question. No, don't worry, no worries at all. If we can now just go to the memorandum of 1188, which we looked at before very briefly. Just to be clear, your lawyers want to rely on this document. So what I want to do is just go through and see which bits of it you consider to be accurate or not, because it may be that you don't think everything's accurate, maybe you do. So I'm just going to pick out the main bits and see where we get to. But if we start at 1189, he says that the last, this is the cover letter to the memorandum, where he says the last few lines. He says I successfully did most of the financing, the full structuring, and executed alone the HSBC part on behalf of Mr. Dazi. And he says I did so wearing a blindfold. As I was not involved in the negotiations between the principals and did not know Mr. Mezi Dazi's ultimate agenda, which resulted in this legal mess. So do you accept that he wasn't involved in the discussions between the principals?
No, he was not involved in discussions between Mr. Dazi and KHALED MUHAIRI. Well, he may have been part of them. Probably not all of them, but I'm sure he was involved in some of them, but the majority, I would guess not.
Right. So he would obviously he wouldn't be able to comment, at least not with any authority, about such negotiations.
Well, I think he could comment on what he. Sorry, I'm interrupting you again.
No. Go ahead.
I think he could comment on whatever he had knowledge of, but but nothing beyond that. So I don't know what he had firsthand knowledge of, and if there's any conjecture here, I'm not aware of what's conjecture and what is actually based on his knowledge.
Yes. So let's go to paragraph 3, the purchase of the facilities from HSBC. I think we can agree that on the 28th of January 2016, EVL purchased this debt for 99 million debt for 24 million at a discounted price.
I think that's incorrect because I believe EVL purchased. It was split between EVL and ECL. Let me just read that, please.
That's your view, okay. A 1191.
Oh, sorry. He spells it out here. He spells it out. Yeah. If I read the rest of it, he shows the 47 to Odyssey and 52 to GSS. I believe that's correct.
At 1191, just at the top of the page, he says CAM is Mr. ALMHEIRI is not the ultimate beneficiary of EVL. He's saying he's not the ultimate beneficiary of EVL, as there's no nominee agreement in place. Legally in the UAE, I mean, you don't have to comment on the law, of course, but do you disagree with this, or do you say that Mr. ALMHEIRI is the ultimate beneficial owner of EVL?
Certainly, Mr. ALMHEIRI was the ultimate beneficial owner of both EVL and ECL, in my opinion.
On the same page, towards the end of the page, you'll see some bullet points there in line form. And it says, last but not least, you can see that MEE is Mr. Araj. He communicated to Mr. Cameron that not only had he entered into the indemnity agreement, but that he also provided the security check to Mr. Dazi. So do you accept that as being correct?
Well, but at the time that I executed my indemnity, yes, that was correct. And then afterwards, in October of 2016 in Paris, Ezelldine acknowledged to me that his check was never handed over.
So just to be clear, Mr. Araj lied to you, is what you're saying now, in relation to the security check at least.
Yes, he did.
If we can go to page 1192, we may have dealt with this already, but just in the top, just before the section 6, there's a sentence that says, JC had to issue the 92 million check in favor of Abdul Dazi and not Mr. ALMHEIRI upon request of Mehdi Dazi, which is unusual to say the least. So is that correct?
Well, I don't know if it was unusual. That's what I was asked to do, and it was further supported by a request from their lawyer, Baker McKenzie, to do the same. So if it's unusual, you would think the lawyer would have flagged it and told them don't have the check issued to Abdulaziz Dazi, but that's what I was told to do, and that's what I did.
Okay, if we can now go to section 7, and there's a paragraph there. The first paragraph, and you can see you write the last sentence. Firstly, the earlier bit of the paragraph talks about the checks, and it says that Cam and JC are the only persons involved in the transaction who are financially exposed. It says, furthermore, neither Cam or JC have received any benefits or consideration from their indebtedness and exposure, whereas Abdul Dazi is now the sole owner of EVL. So would you agree that what Mr. Nejad is saying is that both you and Mr. ALMHEIRI are exposed? You're exposed through the check, and he's exposed, I'm reading into this, in relation to the loan, QNB loan. And would you accept that that is the case, that neither of you have received benefits?
Well, neither of us. I agree that neither one of us had received benefits. As I stated previously, I believe KHALED, I know KHALED was the beneficial owner of EVL and ECL. I understand later down the road, even speaking with KHALED, my interaction with KHALED, he got in a dispute with the Dazis, and they refused to transfer the two Eladis back to him. They were in fact looking for an indemnity to do so. At least Abdulaziz, who was holding on KHALED's behalf, wanted to have an indemnity. And KHALED went back and forth, and he was unable to convince him to do it until ultimately he did so in whatever it was, 2020 or whatever's indicated in the Scouts agreement. So I believe that statement that Manil made it at the time is correct, although on one point I differ, that KHALED was the UBO of EVL at the time.
Understood. If we could now go to the conclusion, which is at 1193. There is, and the second bullet point down, whereas Mehdi Dazi originally communicated to JC that Mr. Al-Mahdi and Mr. Araj would also provide Mr. ALMHEIRI with the indemnity agreements and security checks, it turned out that only JC had done so. So just stopping there, do you agree with what Mr. Nejad is saying here, that it's Mr. Dazi who communicated to you these things?
I think all he's saying here is that I didn't benefit from the agreement, is what he's saying, unless I'm missing something.
I think we're looking at the same thing. I'm looking at the conclusion section, the second bullet point down in the first sentence of that.
Oh, the one
where he's
that
saying-
starts with whereas, you mean?
Yes.
Okay,
So,
hang on.
but yeah, just to be clear again, I'm asking the question: is he correct when he's saying that Mr. Dazzy communicated to you that Mr.
Yeah,
Araj and Mr.
Hey,
Harry would
just take a moment to read it, please.
Yeah, go ahead.
Okay, so could you repeat your question pertaining to this paragraph?
Yes, of course. So the first question, just taking the first sentence, is: do you agree with what's being said here, that Mehdi Dazzy communicates to you that Mr. Al Araj and Mr. Al Mahdi would provide Mr. Al-Mahiri with the indemnity agreement and the security checks? In other words, do you accept this as communication?
Yeah, I hear you. He definitely communicated that Mr. Al-Raj would provide check and indemnity. I recall him, he definitely communicated that Ali Al-Mahdi, if that's what ASA is, would provide an indemnity. I don't recall him telling me that Mr. Al-Mahdi would provide a security check.
Right. And Mr. Nedjar, he would have got this information from you, from the discussions with you in Paris?
No, not at all. Actually, all this information is from him to me. When I was more or less in the dark of with respect to what actually happened until I met him in Paris. Until that point in time, I wasn't aware of most of this. He's the one who shared this information with me.
Well, on that point, on this point that we're looking at now, the first sentence, you wouldn't have been in the dark, because what it's talking about.
I was referring to the fact that there was no indemnity. The other paras of the memo that we have already gone through, where I learned that I was the only one who ended up providing for example, the indemnity and security check.
Let's just focus for a moment just on this first sentence.
Sure.
This first sentence, which deals with the communication to you. This, again, the risk of repeating myself, but I just want to make sure I'm being clear enough, that this information comes from you, possibly from your meeting in Paris. That's how Mr. Nedjar knows about this particular point.
No, not at all. Mr. Nedjar worked hand in hand with Mr. Dazzy. Of course he knew this. Of course he knew that Mr. Dazzy communicated this. I didn't understand your question. Now I do. Of course he was aware.
I mean, you've answered it. And then let's go to the second sentence. Mr. Cameron only discovered this at a much later stage, since Mr. El Araj and Mehdi Dazzy lied to him and communicated that not only had the others, including Mr. El Araj, entered into the indemnity agreement, but they'd also provided their respective security checks. So again,
that information was disclosed to me from Manil himself.
But again, this involves communications to you. So you discovered this at a later stage, the true position. And then, but what it says here, the important words are that Mr. El Araj and Mehdi Dazzy lied to you. And do you accept that that's correct? That Mr. El Araj and Mr. Dazzy lied to you?
Yes.
And they were lied to you because they said that others, including Mr. El Araj, entered into the indemnity agreement. So the word there is others.
When you mean others, you mean Mr. Mahdi, right?
I'm just going what's written here. You've got the word others, and I'm going to suggest that includes other people, including Mr. El Araj and you, of course.
No, he means Mr. Mahdi. There was no one else.
Okay. But your position, you accept the statement here that you were lied to by Mr. El Araj and Mehdi Dazzy in relation to the indemnity agreement and the security checks. That both those people were lied to you.
Yes.
And there's nothing here, certainly not in this conclusion, to suggest that this lying was taking place on behalf of Mr. ALMHEIRI, was that?
In terms of whatever came out of Mr. Araj, no. With respect to Mr. Dazi, he was acting on behalf of Mr. ALMHEIRI. So whatever he discussed with us, statements he made, were assumed to be on behalf of KHALED when with respect to these transactions in question.
But
For example, he didn't make the statements independently as Mehdi Dazi. He made them on behalf of KHALED ALMHEIRI.
Well, that's precisely the point I'm making. There's nothing in this memorandum that we've looked at least so far, and certainly your counsel can take you to other parts, that suggests that's the case, is that?
Okay.
Would you agree with my statement that, in fact, let me just add to that. In fact, what we've seen is that what Mr. Nedja is saying is that both you and Mr. ALMHEIRI seem to have been hard done by. He's not suggesting that Mr. ALMHEIRI is lying. There's no suggestion of that.
Yeah, I think what happened here is that Minil had a terrible fallout with Mr. Dazi, and he probably, was a little bit biased when he drafted this, and he tried to paint Mr. Dazi in as dark a light as possible. But I don't see what you're referring to here. I don't see any statement from him saying that, for example, Mehdi Dazi did this or said that because he was told to do so on behalf of KHALED.
There's also nothing that we've seen about anyone representing to you about having shares in or control over EVL and ECL. We haven't seen any reference. Do you recall any reference in this memorandum?
Well, you read it, so if there was one, you would see it. This is this is one 8-page document, or I don't even know how many pages it is. It's one small document. We're referring to a multi-year, very complex transaction. Right. To capture everything would be a book rather than a small memo. You can't expect them to have captured everything that transpired over that period of time. As I said to you at the onset of this discussion on this particular memo, my concern at the moment, at that time anyway, was the security check. And so I was wanting him to provide me with a memo, in his words, that would help me in the event that that check was cashed.
Well, we'll come back to some of the points you just made in a moment, but there's also no reference to any equipment lease as being a promise in this document, as far as you recall. Certainly in relation to what I've shown you. Would you accept that, or do you recall that there is some reference?
I will accept that whatever is written in the document is written in the document, so you don't have to go through each paragraph.
I'm going to make a submission to you, and your counsel can tell me if this is correct. But there is no mention of the control, the shares and control or even share interest in ECL, this alleged promise to you, or indeed the promise in relation to equipment leases. I'm going to suggest to you that the reason that there's no mention of it is because you didn't tell Mr. Nedja about it, either in Paris or at any other time. That's the reason why it's not mentioned, is it?
As I said, the request for this document was specifically with respect to the outstanding security check.
Putting the document to the side for a moment, you didn't mention these points to Mr. Nedja, did you, prior to this point in time? In other words, you never said to Mr. Nedja, and I was promised shares in ECL.
Well, I mean, I didn't have to tell him because he was part of the dialogue at the time. He was well aware of that already.
And you also never mentioned to Mr. Nedja that you were promised that the equipment leases would be signed.
Again, I'll let you finish. Sorry. Again, he was an integral part of this. This was nothing that I had to mention to him. He was well aware of it.
And I'm going to put to you the reason that you never mentioned Mr. Nedja is because, in fact, there was no alleged representations to you in relation to those things, was there?
Of course there were. In fact, if you look at your client's own submissions, he even references the framework that was put in place, and he references the lease agreements.
You also want to rely on some of Mr. Araj's evidence, despite having said just a moment ago that he lied to you, So if I can take you to his witness statement at D54 at 891. Sorry, that's actually not his statement, but it's worth just stopping here on our way. This is just him witnessing your signature on the indemnity agreement. If we can now go to 146, which is C2 146.
It's okay, I bring it on the screen.
So you can see paragraph 25. This is a paragraph that's come up before in this proceedings. It's a long paragraph, but it starts off by discussing the issue of the indemnity. And what Mr. Araj is saying is rather like you. He's saying he's been led to believe that you and Mr. Almani provide indemnity, but he says something different to you. What he says is these were arrangements that the claimant, I'm looking at the second sentence, that these were the arrangements that the claimant, the second defendant, Mr. Ali Sharif Almadi, and I had discussed and agreed upon at the time. So
sorry, I'm trying to find that.
Okay.
Para 25. Okay, I see. These were, yeah.
It's
Oh,
five
sorry.
lines down.
Yeah.
Yeah, 5 lines down. You have it?
Yeah, I see it.
Maybe just look at that for one moment and I'll ask you the question.
Okay.
Just one sentence.
This this statement, sorry, this is which witness statement is?
This is Mr. Al-Araj's witness statement.
Okay.
And so the point that I'm making in relation to this sentence is that this is not something that you say is the case. You don't say that there was an agreement between Mr. Almheiri, between you, between Mr. Araj, and between Mr. Almadi, that Mr. Almadi would be providing a similar indemnity to Mr. Almheiri.
But what he doesn't say agreements, he says arrangements.
Well, it says discussed and agreed upon at the time. So what he's suggesting is
Arrangements.
the four people, including you and he, had an arrangement and an agreement, in fact, that Mr. Almadi would sign an indemnity. But that's not your evidence. So would you say that this didn't happen? Do you have any recollection of an agreement to that effect between 4 people?
Well, once again, he uses the word arrangement, not agreement.
Well, just if you go to the end of the sentence, and I talks about all the different people, and I had discussed and agreed upon at the time. So he
Okay,
does
agree.
talk about.
Sure.
So
They would, yeah, just like many of the other items that we've discussed during our session today. I'm sure, it doesn't have to be documented in writing. It is agreed upon. There's so many facets of these complex transactions with the 2 banks and everything else. And there were many things discussed and agreed upon. They weren't, noted down each step of the process.
that's not the point that I'm asking, Mr. Cameron.
Okay.
What I'm asking is, do you recall an arrangement or an agreement between 4 of you, like the one Mr. Araj is discussing here?
Well, I believe this is more or less, this is exactly what I've been saying all along, that there were four parties and we were each to get a 25% stake initially. And then once the debt was paid back, the 25% sitting with Mr. Ahmadi and Mr. Muhari would be transferred to Ezelldine and I. I think I'm saying the same thing.
Mr. Cameron, this is not about transfer. This is about the provision of an indemnity. So we're talking about the provision of indemnity. That's point number 1. And point number 2, it's not.
Okay, can I just take a minute to read it because I only read that one sentence.
Yeah, but just for fairness, I'm just going to remind you what your own pleadings say in this case. You say that you were told by Mr. El Araj and Mr. Dazi. This doesn't say that. This says something different. So just to be clear, so there's no hiding what I'm trying to get at. I'm saying your evidence is different to this. Do you understand?
Yeah. Can I read it, please?
Of course, of course.
Because I just started at your sentence. I didn't read the preceding sentence. So just please. Okay. So I believe this
So-
is a correct statement.
You think it is a correct statement? Okay, so,
Yes.
so the point I'm going to put to you is that's different to what you have said yourself. You haven't referred to an arrangement between 4 people. What you've said is you were told by Mr. Dazi and Mr. Araj that Mr. Almadi would provide an indemnity. So are you changing your evidence?
I've said all along that the agreement, arrangement, the structure, whatever you want to term it as, was that the 4 persons, Mr. Mahdi, Mr. Mohari, Mr. Araj, myself, were each to take a 25% stake in the business from the get-go. And then I said, once the debt was retired, Mr. Mahdi and Mr. Mohari, who want to exit the business, would transfer their stakes to Ezelddine and I at a nominal fee. I've said the same thing all along. This is just saying this. He is saying the same thing, just using different verbiage.
Well, we're not going to accept that. I don't think it is the same thing, but I'm not going to enter into a debate with you now. But I do want to correct one thing you said just now, just to make sure you understand. But you repeated again the issue about control and shares, when this issue here is one of the indemnity. So I just hope that you appreciate that. But what's been put to you is that Mr. Araj refers to an agreement in relation to Mr. Almadi providing indemnity.
No, I understand that the indemnities were to be signed by the 3 of us. I understand that.
Now moving on to the second part of this paragraph, it is correct that this now goes on to talk about the shares. And it says that it talks about 4 people remaining in the business. And then it says the agreed intention was that we would all receive shares in ECI and EVL, as it was the 4 of us who would effectively control Odyssey and GSS, right? And then he says, I was willing at the time to shoulder some of the financial liability in respect to the loan. So do you agree with him that 4 people were meant to receive shares? Is he wrong or right? And that was agreement.
The 4 people that I've been mentioning all along, yes.
Yes. I mean, he said he talks about, again, an arrangement or an agreement. He talks about the agreed intention. Do you say there was an agreed intention?
You can call it agreement, an arrangement, an understanding. It's all the same. But that understanding is my understanding. The 4 of us were to each retain shares.
Right, but he doesn't talk about the 50%, does he? Nor does he say 25%, although one can assume that, but he's not talking about the 50%, is he? So that part of the equation is not there.
Okay.
And that's because there was no representation about that or agreement about that, was there?
Well, actually, in one of your own submissions, you refer to the 50%.
Can we now go to C4, page 176?
Okay.
And I'd like to look at paragraph 121. So just for clarity, this is a witness statement submitted by Alexandra Mary Lester, who was a representative of your former lawyers, Clyde and Co, I believe.
Yes.
Do you recall the statement? Do you recall seeing the statement?
Yes.
I appreciate you may not remember everything in it. I mean, it's got many paragraphs, but
I mean, if it was a witness statement that was submitted on my behalf, obviously I would have received a copy and read it, approved it, signed.
Yeah. What the statement does in part is explain. This was put in quite early in the proceedings. And what it does in part is explain why there's a need for comprehensive legal submissions of factual evidence and cross-examination at a merits hearing, because you will recall there was an application by our side for an immediate judgment in which you resisted.
Yeah.
And yes, what Ms. Lester is saying is that if you look at the last sentence, she's saying the second defendant intends to call evidence from and cross-examine a number of witnesses in respect of disputed facts. And then there's a whole list here of 13 different names of witnesses that you're calling, and you can see that what the claimant you'd like to call or cross-examine. Well, you've achieved that. The first defendant. So that's suggesting that you would be calling Mr. Araj. But,
yes.
You didn't call Mr. Araj to cross-examine him, did you?
Well, can I answer that?
Yeah.
At the time that this list was provided, I was told by Alexandra that I had to, although it was early in the proceeding, provide a list of whatever potential witnesses I would call, even though it was way ahead of the trial date or anticipated trial date. Now, since then, many things have changed. In terms of Mr. Najjar, I learned from KHALED himself that he was hired by Ezelldine in, I think, June 2021 and became an employee of one of Ezelddine's companies. And then I learned, for example, of the settlement agreement between Ezelldine and KHALED, whereby my name is part of the illicit group and everything else that goes with it. Obviously, calling those two witnesses would be counterproductive because they already had nefarious intentions against me. In terms of other potential witnesses, my lawyers interviewed 3 or 4 of them. They interviewed James Herman. They didn't feel he had anything material to add. They interviewed Lorenzo, which you already have the witness statement for. They interviewed Mohammad, which was the second last general manager of the company, and he was actually cooperating quite well. And then the outbreak in Syria occurred, and he kind of vanished on us. And there was one more that they interviewed as well. I can't remember. One more. Shrikant Chakravarti, who was our CFO, was intimidated by both Mr. Araj and Mr. MUSABEH and refused to cooperate, and he conveyed that to us multiple times. And the majority of the remaining, I don't know, 5, 6, are all employees of one of Mr. Araj's companies. So that's why, although I listed that group of people, we only ended up calling a couple of them. And unfortunately, 2 of them, which I would have really appreciated statements from, being Mr. Chakravarti and Mr. Kirknawi, for the 2 reasons I just outlined, didn't provide those statements. But that's what happened, and that's why we only had the 1 witness statement.
That's all useful, but isn't the real reason that none of these people would support your case?
Actually, the real reason is the one I just told you. Now I have the list in front of me. It makes it easier for me to go through. So Mr. Ahmadi is in prison. James Sherman, I already answered. Mr. Al-Araj is Ezelddine's brother. Mr. Al-Nawaz is in Jordan. He left the country and he has a dispute with Ezelldine. Mr. Kraga is the president of Ahmad Fassers. Mr. Chakravarti, I just explained to why he wouldn't participate. Mr. Raywanj is the general manager of their operation owned by Mr. Al-Araj in Oman. And Mr. Batrari is Ezelddine's brother-in-law.
Okay. I have no further questions for you, Mr. Cameron. Thank you so much.
Thank you.
Well, thank you. Mr. De Wolf, do you have some re-examination or not? Sorry, I should have asked Mr. Bumaha.
Well, indifferent, Your Honor, but thank you. I was just going to say, I believe that the next thing on our agenda is a brief recess, and I would appreciate a recess. Oh, apologies. Sorry, I misread that entirely.
You're
Sorry.
killing me.
No, I'm sorry. I would appreciate. We've gone through 2.5 hours of examination, Your Honor. I would appreciate a brief recess. I could go through my notes.
How long do you want?
Well, say 15 minutes and say 10 minutes. Sorry, 10 minutes.
Any objection to 10 minutes, Mr. Ball?
Not from our side, no.
Let's adjourn for 10 minutes. And again, Mr. Cameron, please don't talk about the case in the meantime.
Sure.
Right, we'll resume in 10 minutes.
Thank you.
Thank you, Your Honor. Yes, Your Honor. We have 20 minutes and 5 questions.
Very well. Let's start with question 1. Let's see how we go.
Question 1, Mr. Cameron.
Yes.
We've earlier, counsel for the claimant, discussed with you the misrepresentations you say were made. Now, leaving to the side Mr. El-Araj, what were you say the things that were said to you by Mr. Dazi?
The key representations that motivated me to move forward with this opportunity were, 1, that the loan would be procured by KHALED, which he did do, and the loans would be serviced by the equipment leases of the 2 companies. and that there would be guarantees issued by myself, Mr. Araj, Mr. Ahmadi, on the same terms and conditions, and that we would receive shares in the businesses, initially only 25%, and then once those loans were repaid, the remaining 25%. So ultimately, Ezelddine and I ended up with 50% each.
Mr. Cameron, I'm afraid that the privilege of the 4 next questions belong to Mr. De Wolf.
He looks angry.
Always, it's just the German nature in me. I've got 4 points, Mr. Cameron. Counsel for the claimant took you to an email. I believe it was an exchange between Mr. Nejar and HSBC. And there was a reference to investors. Do you remember that? When
Yes.
that question was asked?
Yes.
To your understanding, who were those investors? Which people or companies?
To my understanding, the investors were the 2 SPVs, so ECL and EVL, and the 4 persons behind them, which were myself, Mr. Araj, Mr. ALMHEIRI, and Mr. Ahmadi.
And if I could take you to a document, it's at 1113 of the bundle. You'll see it on screen. You can zoom in on that. There's a reference to EVL team. Do you see that? It's an email from Baker and McKenzie.
Yes.
What was your understanding of who was part of that EVL team that Bakers were advising here?
As you know, we're currently assisting the EVL team. The EVL team would have been Mehdi Dazi and Manil Najar.
Okay.
Oh, KHALED, of course.
And then a lot of time was spent on this Mr. Najar's memorandum. If we can pull that.
Sorry.
If I can just go back to that, Neil, Abdulaziz at that point in time as well, because he was the...
Sorry, John, sorry, just before we lose this, it just says inaudible. You answered the EVL team would have been Mehdi Dazi and Manil Najar is the way that the transcript reads. And then it says inaudible, of course. Just could you clarify that? You said and
Abdulaziz Dazi.
Okay, thank you. And I mentioned before the Manil Najar's memorandum. A lot of time was spent on that. That's at 1188. If we can pull that up on screen, please, just the first page. And zoom in on that very first line. And Mr. Cameron, you weren't told in what context and with reference to what questions this memorandum was prepared. If you could read that first line to us, please.
I write with reference to your request for a summary of the indemnification/security mechanism between yourself, Mr. Khaled ALMHEIRI, and Ezelddine Ventures Limited, and its affiliates, which are ultimately owned and or controlled by Mr. Abdulaziz Dazi and Mr. Mehdi Dazi.
Okay, thank you. And then in addition to a memorandum, Mr. Najar also gave a witness statement in these proceedings, quite early on in the proceedings. I'll just take you to that. It's at 156. If we can just go to the first page of that statement, just to show that that's that document that we're looking at. Thanks. And then back to 156. That first paragraph there, if we just go a bit to the top. If you can have just a moment to read that, Mr. Cameron.
Okay. I think we're missing part of the first sentence in the preceding page.
Yeah, paragraph 14. And then that goes over the page.
Sure. Okay.
And then the question is just whether what's set out here is consistent with your own sort of understanding at the time.
So what Manil told me when I met him in Paris in November of 17 was that when he received the envelope from Ezelldine, it was a sealed envelope, and that he flew to Paris the next morning and he handed the envelope over to Mehdi, and that he never opened the envelope at the time. And that he later was informed by Mehdi that contained within the envelope was an unsigned indemnity agreement, is what he had told me. And in terms of the check, he told me there was no check. And as I had mentioned earlier today, when in Paris meeting with Mehdi to try to resolve the outstanding bottleneck along with Ezelldine, during that visit in October 2016, Ezelddine himself acknowledged to me that the check wasn't handed over. He had some ridiculous excuse, like it fell out of the envelope and it fell between the seats and my driver found it between the seats, something like that. So that's my recollection with respect to both the indemnity and the check.
Okay, thank you. And the final point, I think you said something about there being a reference in the claimant's pleadings or submissions about the 50% ownership of the two SPVs.
Yes.
Yeah, if I could take you to 181 of the bundle. It's Mr. ALMHEIRI's first witness statement, and zoom in on paragraph 7C. What Mr. ALMHEIRI says there, what the purpose of the restructuring was.
Mm-hmm.
Is that the reference you were referring to, or one of the references, perhaps?
That's one of them. There's another one as well. I think maybe in the skeleton argument or one of the more recent statements, but this one is pretty clear.
Okay. Thank you, Mr. Cameron. That's all the questions we have.
Thank you.
Well, thank you very much, Mr. Cameron. That's the end of your evidence, and you're free to go now.
Thank you.
Although, of course, you can stay if you wish to. That concludes the evidence for today, and I think tomorrow we go straight into closing submissions. Is that right?
Yes, it is, my lord.
Can I just say this? It would help me. I don't want to cramp your style at all, but it would certainly help me both following tomorrow and also subsequently when I have to consider all the evidence. If each side could do a short note. It doesn't need to be fully argued and grammatical and everything like that, but just point by point, the main points they say they get from the witness evidence and how it ties in or doesn't tie in with their case. I don't want a long essay on the point. I just want sort of signposts that I can be looking at later when I come to read the evidence again and know that I haven't missed some particular point.
Understood.
So we'll resume then tomorrow morning at the usual time.
Before we do, I just have a few housekeeping things. They're quite short, if I may.
Yes.
The transcript, what we have is still a draft form, and we've contacted EQI. They haven't provided us what we would have expected as a final transcript with all the corrections made. I don't know what to suggest in relation to that. I mean, we could circulate to the judge a PDF of the latest transcript that we have, and we could all work on that.
Can I interrupt you? I'll send my clerk, and she'll confirm this, Lena will confirm this, sent me this morning a transcript. I'm not sure I haven't opened it yet, so I'm not sure whether that's a final revised one or whether it's still a draft form. Lena, do you know that?
Your Honor, I believe it is still a draft form,
unless
I'm wrong.
Yeah, thank you very much. So, Mr. Bohr, it was your...
Sorry, could I? It's the transcriber here. We did produce a fully edited transcript last night, so I can check with our office that that was what was sent out. It should also have been updated on the TMX where you're seeing the live transcript. If you click on yesterday's transcript, that should be the updated version. If it's not, I can contact our office and make sure they send you the fully edited, but that should have been sent already.
I think, I don't know what I've got. Mr. Ball seems to think he only got a draft transcript, is that right? And
Yes, it sounds like from what we just heard that from your club that you have that as well. But there may well be a more up-to-date one. I mean, maybe if I may propose, if EQI could circulate to the parties and the court the latest, then we're all at least working off the same document.
well, can I just leave it to the parties to discuss with the transcribers how we make sure we all get the same finalized version of the transcript, something we can treat as final. And from my point of view, it's something I can download subsequently to highlight and all that sort of thing. So I'll leave that to you, Mr. Board, to discuss with the other side, just to make sure we're all working on the same document. Was there anything else you wanted to raise?
Just one more matter. That's you asked us to try and agree the translation. We're still waiting for the other side. We suggested that we use the James Wheeler translation, which we have already in the bundle. I don't know whether my learned friend will object to that or not, but that hasn't yet been agreed. But we're hoping that they will at least.
If you can sort that out by tomorrow morning,
yeah,
that'll be helpful.
Oh, great.
So long as I'm told what I've got and whether there are any rival versions which may make a difference. Okay. So we'll resume. Anything else?
I've just been asked about the timing for the note that you requested. If we send that tomorrow morning sometime, and then you can follow along with us, would that be suitable for you?
Yeah, yes, but as I say, it needn't be a very lengthy or grammatical note. And if I have it even at the end of the submissions, it would do. But obviously, it's easier if I have it before the submissions in case there's some reference to be made.
Yes, understood. Thank you.
Thank you both. Thank you all very much. And we'll resume usual time tomorrow.
Thank you.
Thank you.
Thank you.
Good day.